My lord, my revisional application released on 11th June 2024 and did not assign the matter.
Nobody is willing to hear any of your matters unless you had given a letter of apology. Based on that, the matter was assigned. Once again, you have created a problem in that court. Therefore, the Honorable Judge is released.
My lord,
But if you want to argue your matter, you please.
my lord, if my allegation as per divisional application wrong, give me punishment, exemplary punishment. If right, exemplary punishment of accused judges of Calcutta High Court. Regarding my case, please see. My lord,
You give
regarding my case, Honorable Chief Justice Division Bench has no power to judge or comment on the said matter except larger bench as per the order of Honorable Supreme Court in connection with review petition civil number 1620 of 2023 in civil appeal number 1661 of 2020 order on 3rd January of 24 as per para number 20 and 24.
You give a letter based on this judgment. We'll listen.
My lord, you knows everything. Why ordinary citizen of India and any administration
You please give a letter. Let us
to obey, to bound and obey your judgment and others Honorable High Court judgment. Where Honorable Judges of Calcutta High Court have deliberately disregarded and disrespected by Honorable Supreme Court judgment.
You please give a letter on the administrative side. Yes, yes.
The matter has been disposed on 20th June. This matter, man. I was appearing for the corporation.
Your name is not there.
Not there, and unfortunately, maybe missed, my lord.
All right.
My lord has noted that advocates of Howrah Municipal Corporation is there. My lord, I have noted, my lord.
Case list.
In the first page.
Yes, sir. Yes, sir.
My lord, my apologies for bothering your lordship, my lord. This is with regard to the death of 4. Any date, my lord, fixes, because, my lord, otherwise they will be denied justice.
It's a PIL.
It's a PIL, my lord. Thursday at any
11th July.
11th July, my lord. Grateful, my lord. Hey, 11th. I'm grateful.
Draw your attention to 3 orders. One notice issued by this Honorable Court regarding the appearance before the court, not before any court, for hearing and determination of the content rule. When you see this rule, it's accurate, misleading, and my lord, this suppress the
Yes, what happened to
it
the
was
rule?
served upon the domestic help. There was an order which has been perhaps withheld before my Lord Chief Justice that the rule should be returnable on 18th June and be placed before the Honorable Chief Justice. But the notification dated 14 by this Honorable Court found that it has been assigned, specially assigned to Justice Bossak's bench. Therefore, the Assistant Registrar signed this order on 12th. And it was subsequently served upon the domestic help. So, knowing fully well that there was an order, because there is
what do you want from us?
There should be an inquiry why this has been happened, because it is deliberately done.
On oral mentioning, we can't do
No,
anything.
but that is that, my lord. Okay, I'll file a.
Or whatever it is, you please call the list.
But only one thing, I am mentioning item number 812 of the monthly list. But you will also know that the Madrasa board did not hold the election for long 29 years. You will also directed them to give an explanation of why this election has not been held for long 29 years. But this matter is running in the list of the combined list. Let it be listed in supplemental list. Under the when your loss will
You
take
please give the letter.
I am giving the slip, my
Yeah.
lord. Let it be taken on Thursday.
Appellate,
My lord,
You
that-
please give.
that
appellate
was,
said-
my lord assigned the matter, they are returnable on 18th of June. Therefore, the order has been withheld before the honorable court that it will be on by 18th of June placed before the honorable chief justice.
Let us see. Yes.
appellate side daily list, serial,
Only I am mentioning only one thing, Lord, item number 48,
48.
but may not be taken up by your lordship because the judgment has been passed by the honorable justice Hiranmai Bhattacharya.
Okay.
That's
So
why
48.
may not be taken up.
Since this appeal is against an order passed by one of us, so we will try to give your lordship's name. The matter stands released and the papers be placed before the chief justice for appropriate. Yes.
item আপনার ছিল
serial number 1,
What is the correction?
I picked up for that, my lord. Yeah, my lord. Regarding the same dispute, my lord, already, my lord, an arbitration has been commenced by the respondent, my lord. They have initiated arbitration proceeding. Just kindly see your last order, my lord.
No, why is it appearing to be mentioned?
My lord, because my lord, regarding this matter, my lord, already an arbitration proceeding has been started, my lord. And what the landed arbitrator has commenced the office, my lord, and directed to statement of claim. Now, on the other occasion, your lordship was of the view, my lord, that this dispute should be referred to the arbitrator, my lord. Kindly see last order, my lord. That for that reason, it is here, my lord. And my lord, the arbitrator has already commenced, my lord, and this is the order, my lord. Last order passed, my lord.
So according to you, nothing survives in the appeal.
Last hour you in the appeal, my lord.
But who's appearing for the respondent?
Devjyoti Basu was appearing, my lord. He was representing, my lord. Mr. Devjyoti Basu.
Where is Mr. Basu?
If your lordship wants, my lord, your lordship can pass over, my lord. I may call them, my lord.
Yes.
Lord, I beg to appeal for the ECL authorities. Lord, I'm being led by Mr. Devjyoti Basu.
But I am for the ECL authorities, my lord. He is for the petition.
Now they say you have already commenced arbitration proceedings and notice of preliminary hearing.
Notice of preliminary hearing was given, my lord. My lord, the arbitration proceeding with regards to various other claims, my lord, also with regards to the loss that I have incurred. My lord, but then the subject matter of the writ petition below, before the single bench, was with regards to the legality of the banning.
Legality of the
Legality of the banning order.
But banning order, you have not questioned in the arbitration.
That
Only,
is also issue, my lord. In their notice, my lord, they have mentioned.
my lord, only with regards to the claim incurred,
Their
only
loss-
with regards to the
their
loss
loss
incurred
will arise, my lord, from the
during
banning
the
order.
course of banning.
No, where is the claim petition?
My lord, the statement of claim is yet to be filed on 13th of July.
All right, let them file. If they question the banning order also, we can accordingly consider. Hear Mr. Basu and then pass an order.
As you also.
Matter has been listed under the caption to be mentioned. It is submitted by the learned advocate appearing for the appellant.
My lord,
But the
one
respondent-
small prayer, my lord. My lord, they have floated another tender with regards to the erstwhile tender in which I was banned, my lord. Kindly stay that, my lord. Otherwise,
Cannot be, my lord. Already, my lord, work order has been issued.
my lord, work order
For
has
the
been
appellant
issued. I
submitted
have not been able to
that the
given an
respondent
opportunity
has
of
already
participating
initiated
in the tender despite the order of the
arbitration
single.
This fact is not disputed by the learned advocate for the respondent, but would submit that in the writ petition, what was questioned? No, in the writ petition, the order of banning of business was the subject matter. And the respondent would make submissions in the appeal. It is further stated that the statement of claim before the honorable arbitrator is to be filed on 13th of July. On what date you have to file the statement of claim?
My lord, on 13th of July.
On 13th of July. Hence, let the matter be listed on 22nd July. Remove from the caption to be mentioned. Yes. Next. No, remove from the caption.
Serial number 2 and 3.
Yes.
Lord, item number 3 is the state's appeal. Item number 2 is my learned friend's
Yes,
appeal,
my
the
lord.
private respondent in the
Lord,
writ
we are-
petition. We are agreed by the same order, my lord.
My lord, we are praying for at least a week or two's adjournment, lordship, because my lord, the petitioner's family they're having a wedding of their son, my lord. So my lord, they are all out of station and we are been requested if we can put this over after 2 weeks, lordship. Lord, I understand, my lord, but we've also not received our instructions. Our instructing advocate is also not here, my lord, because he's also one of the family members.
The family of the client or the family of the advocate?
My lord, actually, my lord, the advocate is also a part of the family of the client, my lord. So, my lord, they are all at the wedding. My lord, that is why I'm here, my lord. Even the solicitor is not here, my lord.
My lord, there cannot be any urgency subject to correction.
there
by
is
lawyer
a
senior
stay
friend,
order
because this is
also.
our appeal. And in fact, your lordship was pleased to hold that the stay order granted by the Honorable Single after delivering of the judgment that should not operate. So
Yes,
he's
my
not
lord.
functioning as a member of the work board. So urgency,
There was a
if at
direction
all.
issued
Yes,
to
my
the
lord.
city civil court to complete the proceeding.
No, this is not that matter.
Oh, that's a
This is
different-
not that matter.
This is, my lord, a matter when a person
person-
does not fulfill the eligibility criteria and, my lord, hops in, my lord, because of the state's arbitrary act, my lord. He has no qualification whatsoever to be a Shia Islamic
My lord,
scholar.
we can demonstrate that,
Yes, my lord, that is
that
a
is not
matter.
required.
Merits
not
of the
mentioned.
appeal we will get
But
into
what
it.
we are on, my lord, the urgency, if at all, my lord, could be in our part because we appear for the appellants. Well, my learned friend client has been thrown out from the office because of the order passed by the Honorable Single. We have preferred the appeal. I don't know.
Lord, the state has, my lord, preferred an appeal 3 months after, my lord, when the
27
direction,
days delay.
when the direction was to, my lord, act within 3 weeks. So, my lord, a post is vacant for a Shia Islamic theologist, my lord, which is an important post. One can't, my lord, function without, my lord, the filling up of that post, my lord.
No, in
Can we-
this appeal, there is an order of stay.
No, my
An
lord.
order
let
of
me-
stay passed by the Honorable Single Judge, which has lapsed by flux of time. And even then, my lord, when the matter came up before your lordship, my lord, when the appeal was filed by the
Lordship was pleased
private,
not to
your lordship
renew
was
it,
pleased
lordship.
that order of stay should not
So therefore,
operate.
you will have to take steps for fresh nomination.
My lord, we have
Subject to the
subject
outcome.
to the
we have to take fresh steps, my lord, but your lordship may kindly fix a date for hearing of the appeal.
No, that we will do. Parallelly, you
yes.
see,
Huh.
if a particular body does not have the head or.
No, he's not the head. He's one of the member. The body is there. He's one of the member. There are around.
Subject to the outcome of the appeal, you do it.
My lord, your lordship may kindly take.
my lord,
Here's the appeal
This is
because
page 313, my lord, of the
if your lordship
page
can hear
313
out the appeal.
of the impugned order, my lord. Para 74. In fact, 73, my lord.
73. Yes,
73, my lord. My lord, the third last line, the respondent number 1, that's the state is directed to undertake fresh steps immediately for a fresh nomination under section so and so in the post left vacant. And para 74 last lines.
These appeals are by the state and the private respondent in the petition are directed against the common order. Directed against the order dated 17/1/2024 in WPA 187/35 of 2024. When this appeal was entertained, the court was not inclined to grant any stay of the direction issued by the learned single bench. If that be so, the state has to implement the directions issued by the learned single bench in paragraph 73, which is to the effect that the state, namely the respondent number 1 in the writ petition, was directed to undertake fresh steps immediately for a fresh nomination under section 14 within bracket 1 within bracket small d of the 1995 Act in the post left vacant by the removal of the respondent number 2 in the writ petition by virtue of the order passed in the writ petition. Therefore, the state / respondent number 1 in the writ petition is directed to comply with the direction issued by the learned single bench, making it clear that the same will be subject to the outcome of the appeals in MAT number 264 of 2024 and MAT number 537 of 2024. While issuing the required notification, it should be clearly indicated that the process is being undertaken subject to the outcome of the aforementioned two appeals. List the matter in July.
My lord, kindly fix the date, my lord, in July, my lord. We'll certainly be moving the appeal on that day, my lord.
My lord, your lordship may kindly,
29th July.
My lord, can it
My
be
lord-
kept any day before, my lord?
It's not 12th of
First-
August, my lord. 12th
my lord, your lordship,
Lord, August is too late,
Lord,
lordship.
if I am, my lord, if I am supposed
he
to, my
did
lord,
not
this
file
is,
in
this
time,
is the
July,
nominated post,
July.
my lord. If I, my lord, induct some other person, my lord, then my entire appeal will become infructuous. Your lordship may
No,
kindly,
subject to the outcome.
my
Nothing
lord,
will
then your lordship may kindly hear, because I am not paying for adjournment. They are in
Lord,
some
kindly
difficulty.
keep
Then your
it in, my
lordship
lord,
may
first
kindly
or
hear out
second
my
week of
appeal.
July, lordship, my lord. Otherwise, my lord, the appeal
Then
will
your lordship
become.
may kindly hear out my appeal, my lord.
All right.
Because, my lord, I will be,
Nothing will happen, sir. Heavens won't fall. Please. Next.
my lord, I'll be hauled up for contempt, my lord. Your lordship may kindly hear out my appeal, my lord.
We are
Because this
making
is a nominated post, my lord.
Doesn't matter.
Serial number 4 and 5.
Lordship may kindly, my lord, because I am ready in my appeal, my lord.
All right. Today we are not ready.
29 July.
Much obliged.
What is this 4 and 5?
That in this matter, pursuant to your lordship's order on 18th of April, it was a matter of for last more than 2 years and 4 months, election was not being held. One after another cases were being filed. In a public.
Yeah, I don't think he is
litigations-
appearing for the writ petition
No,
on
I'm
any of
appearing
the
for the-
matters.
I am appearing for the direction was on me.
My lord,
Your-
the
no,
matter has come up at our
I'm-
instance.
The
Because,
direction
my
was
lord,
on
the
me.
honorable single judge,
My lord, the election notification pursuant to your lordship's order has been published on 10th of June.
Yes.
All dates of elections are over. Nominations have started yesterday. At this juncture, my lord, they filed another writ petition. Now, fortunately, the learned single judge referred the matter before your lordship. That is the other matter. So, my lord,
kindly,
now the
You should
present
solve the
position
election.
is, my lord,
Solve the
election.
no.
present
For
po-
2 years, the election has not been held.
May I just. Present position is, my lord, 10th of June election notification is over.
My lord, kindly looks
dates of
into the order
schedules
of
are there.
21st June 2024,
And the
passed
prayer
in
in the other writ petition is, my lord, so that they are seeking
15987.
deferment of the election.
WPA 15987 kindly looks into the order, my lord. His lordship was approached, my lord, apropos a challenge thrown to the election commission's order. That challenge, my lord, his lordship felt that since the issue is squarely covered by the other writ petition in public interest, it should be heard by your lordships. And therefore, my lord, I immediately brought it to your lordship's secretariat's notice, my lord, and brought it to your lordship's kind notice. Thereafter, the matter has been listed today.
And what was impugned in this writ petition?
My lord, in the second writ petition, 15987 is a writ petition carried by me, my lord, where, my lord, I have challenged the election commission's order, whereby, my lord, a challenge was thrown by me to inclusion of dead persons in the voters list. Dead persons, admit,
It is not maintainable.
my lord,
Your remedy is by way of election petition. Let
Well,
the
election-
election petition is over. Election petition is over. Post-election petition, I have to challenge it somewhere. And thereafter, I have,
election
my lord,
nominations were called for. Now the election notification has been issued pursuant to directions issued in this appeal. And whatever challenge you will have to wait, you will have to wait till the process is.
May-
Order is about
cut it short.
2nd of
Kindly,
May.
may I just place my writ petition once?
To cut it short, lordship, I appear for the election commission. Entire direction was upon election commission. It's similar election of a primary huge cooperative society where 82,000
Yes,
voters.
we remember, sir, we remember.
Now, my lord, lordship, on the last occasion, directed, issued two directions. One, you dispose of the complaints, if any. And second, you issue the notification, the election program on 10/6. We have complied, my lords, both the orders. My lord, all the my lord, pending complaints which were there, though not likely to be taken up, but even then, those 5 complaints have been disposed of.
But
And
what about their complaint?
their complaint, they, my lord, did not turn up on the first occasion. When, my lord, initial process was going on, they did not turn up. They filed a complaint with the election commission. On the date of hearing, my lord, not in person appeared, but, my lord, the lawyer appeared, but he could not present any document to show that these persons are dead.
That was
Yes.
recorded.
Therefore, and my lord, this is the action taken report. We have very clearly stated, my lord, what observations have been made. Lordship, kindly take up our complaint. I'm giving a complaint report to my learned friend also. Lordship, kindly, my lord, two directions. My lord, two issues have been decided in this way. Part A is the first issue. Now, my lord, first issue, number 1. That's the complaint of the
He is
second.
the writ petitioner.
Yes.
15/2/2024, date of complaint received but did not appear on the date of hearing 20/20/24. Then
And-
notice issued via email, appeared through advocate. Advocate was asked to substantiate the allegation, but he failed. Accordingly, the file was closed.
Now, my lord, point is 6
You
persons.
don't want the election to be
Yes.
conducted.
No,
That's
no,
Number-
with respect,
the long and short of the
no,
story.
with respect,
But
no,
their intention
not-
was to all the election.
And my lord,
For 2
second.
years, the election has not
Lord,
been held.
second is the, 1 second, please. And second is the program we have given. Lordship, kindly see the election program. That is
none of
annex.
them permit me
1
to
second,
address
please.
your lordship.
No, certainly. Kindly excuse me, just one minute.
Fortunately, they are saying that they will not
1
permit me
minute.
to address your lordship.
And my lord, the nomination has been collected. It has been started from yesterday. And my lord, it has been going on.
All right, please, yes.
I mean, kindly comes to page 136 of my writ petition.
You got one more copy?
Yes, we have handed over to my lord.
36.
But this is the order made by the Cooperative Election Commission. That I had brought it to their notice. Please come to page 137.
Hmm.
These persons, by way of complaint, I had brought it to the commission's notice that these persons are admittedly dead. 137 box. Out of whom, on receipt of one death certificate, the serial number 2998, Alok Bhushan Mitro, his name has been deleted from the voters list, admittedly. The commission says that since I was unable, someone's death certificate, I cannot, procure as a matter of course. Subsequently, I have been able to lay my hands on all those death certificates of all these persons whose names figure in the final voters list are on record in your lordship's writ petition.
But why did you not appear?
Yes.
No, you could not substantiate that.
That is the finding of the secretary of the commission, at page 139 kindly.
See, is there are totally how many names? 1, 2, 3, 4, 5, 6.
And
Out of
today there are
80,000.
30 persons whom we have detected who are admittedly dead and whose death certificates are also on record in
Now, my
the
lord, 82,000 voters. If 8%, suppose his allegation is below correct, how that will affect below the process of the election?
persons
His
who are
interest,
All
how
right.
his interest will be
No.
jeopardized.
Now, you have published the list of valid voters. Suppose assuming he has not made a complaint, you have come to know from the respective, primary society. Suppose some member is dead. Are you entitled to revise the voter list?
Not at this stage, Lord. So kindly appreciate one, not at this stage, because everything has been started. Number 1, number 2,
This
they have
will
missed
not
the
have
pass.
a-
And Lordship, kindly appreciate, there are also scopes to come up before the court, because nomination paper would be withdrawn, would be taken up. Now, nomination paper, some members are taking for the election of 122 delegates. Now, below that will be scrutiny. The scrutiny will be there. Then final voter list also be published.
permanent voter list
1
is
second.
already
If
published.
it is no, final candidates,
Candidates.
delegates list will be delegates list. If you found that is not been taken care of, you can also put an objection.
Paragraph
Then,
6,
Milord,
election
again,
starts-
Milord, 1 second. At the time of Milord poll, the dead persons will be also scrutinized, will be also looked into whether that is coming inside or not. So
Paragraph
you are having
16.
chance also. You can take care of. You raise a protest.
If I can demonstrate
And
before the
Milord,
commission.
assuming, Milord, all his allegations are correct, then 82,000 voters, 122 delegates from 122 pockets, then 8% cannot influence the vote in any manner whatsoever, and their interest cannot be jeopardized in any stage of imagination. Then why they are asking to stall the election process?
What I was
Same
putting this
letter.
question, I was putting this question to myself, we have just, before the commission we appeared, we showed them this list. Apart from that, in the writ petition, we have averred about, 2-3 constituencies where admittedly today, as on date, 50% we have detected whose death certificates are on record. And And Milord, those dead persons' names figure in the voters list. They did not even, Milord, their names did not figure in the Milord general election voters list. That is also one of our limbs of submission, Milord. What I was humbly beseeching your lordship, Milord, the final voters list may be revisited. I cannot say that I do not want to stall the election. The election may be deferred for a limited period, 5 days, 7 days, and in the
No, entire process will be jeopardized, my lord. It's a long process.
There is no question of jeopardize.
Long process.
Years the election has not been held, 2 years.
This writ petition in WPA
मेरे फिर
was filed
election stall করবে।
praying for a direction.
সেটা কোথায় supplementary evidence
Praying
করো।
for issuance of writ of certiorari to quash the proceedings dated 2/5/2024
একটা কপি দাও।
in connection with the objections raised by the writ petitioner in dispute case number 6/CEC 2024 and to withdraw the said order dated 2/5/2024. Essentially, the challenge is to the voter list. On the ground that if few of the voters are no more, and despite the same, their names figure in the list of valid voters in the voter list prepared by the election commission. In a public interest writ petition, WPAP 570/2022, the court had taken cognizance of the entire matter, and on 18/4/2024, the following order was passed. Please extract the entire order. 18. In terms of the above order, a direction was issued to the election commission to deal with the objections, individual objections which have been raised before the commission in accordance with the law. A direction was also issued to the commission to issue notification for election on 10th June 2024. In terms of the said direction, the election commission has taken up the complaints which appear to be 7 in number. And the complaint of the writ petitioner, Rabindranath Thakur, was also taken into consideration. When the matter was fixed for hearing by the election commission on 22/2024,
I attended.
the writ petitioner did not appear. Subsequently, another notice was issued by the commission on 22/4/2024, fixing the date of hearing on 2/5/2024. Notice was also served on the writ petitioner via email on 22/4/2024 and through special messenger on 30/4/2024. The writ petitioner Rabindranath Thakur was represented by his counsel before the commission on 2/5/2024. The objection raised by the writ petitioner was considered, and it has been held by the commission that the advocate appearing for the writ petitioner could not substantiate the allegation, and accordingly, the complaint was closed. The total number of voters is stated to be 82,000, and more than 120 delegates are to be elected. The election notification has been published in terms of the above direction in the public interest petition, and on 10/6/2024, and intimation notice has also been published on the very same day in five newspapers, in several newspapers on 11/6/2024, which are having wide circulation. Thus, the election process has commenced, and the question would be as to whether the writ petition can be entertained. This illegal issue is no longer res integra And the earliest of the decisions is in the case of N.P. Ponnusamy, who is as returning officer, AAR 1952 SC 64, wherein it was held that once the election process starts, it would not be proper for courts to interfere with the election process. Similar view was taken in Sri Sant Sadguru. It is here in paragraph 16. So and so. 2001 8 SEC 508.
Citation to keep
Aforementioned decisions have been followed with Honorable Supreme Court. Shaji K. Joseph versus V. Viswanath
29.
2016 4 SEC 429. In any event, the petitioner in his complaint before the commission has submitted the names of 6 persons who are stated to have been dead. Out of the 6 persons, one of the verification was done, and the name of one of the person, namely Alak Bhushan Mitro, serial number 2998, number 5992 has been deleted. Therefore, the objection, it is not a case where the objection was not considered. Rather, it is a case where the writ petitioner was unable to substantiate his claim. Now the petitioner comes forward with the case in the writ petition, stating that there are several other persons who are also dead. These issues cannot be adjudicated at this juncture, as the election process has already commenced. There are sufficient checks and balances in the entire election process, and in any event, the names of 5 persons who are stated to be dead can hardly cause any impact, since the total number of voters are stated to be more than 82,000. Therefore, we find no ground to grant the relief sought for in the petition. WPA 159/57 of 2024 is dismissed. In the WPAP separate order, the directions issued in the order dated 18/4/2024 has been complied with, and the election notification has been issued on 10/6/2024, published in the various newspapers, having wide circulation on 11/6/2024. Therefore, let the election proceed in terms of the notification. Let the matter go out of the list. Liberty is granted to the parties to mention after for inclusion.
So far as my petition is concerned.
Dismissed.
I have got the added respondent. Instruction for it, but my objection is pending. They have not posted of 21st of May. Valid admitted record for he had visited the office of the commission. He was intimated that orders will be communicated.
You can consider.
Insofar as there is another issue, kind your lordship has now not only this. I had raised another issue regarding reservation. They have fixed a date tomorrow. They have fixed a date tomorrow, not the commission, not the bank. And I've handed over that notice to your lordship.
Earlier, there are about more than 10, 12 petitions.
Now, what I was respectfully submitting, to your lordship.
Please, in that writ petition, you add one. In the event there is any other writ petition concerning the present election process, the same shall be listed before this court. And the registry is directed to take note of this.
And I was only, kindly pardons me. I was only praying for a formal.
My lord is keeping the public interest litigation pending till the yes. That
formal.
So, election will
let it proceed. Let us see.
No, election will proceed as usual, lordship. And next day,
I was only humbly beseeching Milord for a formal stay. Your lordship will decline.
No.
Next.
Not required, sir. We will sign. Supreme Court is there. Vacation.
No. Not that. Dead voters. Dead voters and immediately in the writ.
That will not affect anybody's interest.
There is no document.
Yes, sir. Next
This is pending. My writ petition is pending.
Serial number 6.
My application.
Item 6.
My application.
6.
Serial number 6. My application, no, this was mentioned on the other occasion. Your Lordship was pleased to keep it today. This was challenging the lookout circular and the
You
refusal
wanted to go for some
of 5
graduation.
days to Singapore to attend my daughter's convocation. I'll
Would
go
that be
to,
considered?
well, that's been considered, has been refused only on the ground that there is a decree that's passed by the Tetrikavi tribunal against me. Well, the law is clear,
How much is the amount paid?
about 213 crores.
Lovely.
But your Lordships have repeated.
2 zeros less we can ask you to secure. But you have challenged that by way of an appeal.
Well, that was produced in course of the hearing before the learned single judge.
But your client should have been aware.
Well, that's passed in April and it was done ex parte.
No, because
I had once failed
it
to
is all
file.
no explanation.
Yeah, that's right.
You
I
file
must
appeal.
challenge it.
You file an appeal, obtain an order of stay, subject to condition, no condition, etc. Then you can leave.
No, well, the only thing
Suppose
is,
from Singapore, he goes to Malaysia, Malaysia, go to Australia, from Australia.
I agree that's something that can actually go against me.
Other
The
two banks
only
also have
two-
defaulted.
Just act me.
Other
Just
two banks
on
also.
2 counts, your Lordship will test this. Your Lordships have repeatedly held, I'll show 2 decisions, my Lord, that me being declared as a willful defaulter, that a direct recovery tribunal decree,
In which,
Or-
from which university the petitioner's daughter is getting?
SP Gen. With the undertaking that I'll go, my Lord, your Lordships can record that my passport can be cancelled if I don't come back. I'm not a passport holder of any other country.
See, by cancelling your passport, how do they secure the outstanding?
Well, that is,
It's public money, sir. It's
so
public money.
this is what
And,
your Lordships have held.
And he has got all the comforts in life. And imagine the person who has borrowed, like, let us say, a housing loan for 5 lakhs, 10 lakhs. And you can't service a debt. It has crossed 250 crores.
That is
It's a
what
crime
your
against
Lordships have held.
society.
My Lord, for
Crime
recovery
against-
actions, a lookout circular can't be issued. Repeated judgments passed by this honorable court it's been held that just because there is a money action against a person,
We have held
Well,
otherwise.
look, I'm sorry, my Lord.
We have held otherwise.
No,
in
there's
one matter.
There is one additional factor. My Lord, public sector banks were allowed to
We can
issue.
give you one liberty. This writ petition is still pending.
Yes, my Lord.
You file an application before the single bench saying that for these 3 days, you please give me.
My Lord, that is what I had prayed for. And your Lordship will see in the.
No, your writ petition itself was that.
No, writ petition is pending, but to allow me to go on 25th and come back on the 30th with the undertaking that I shall return and my passport can get cancelled if I don't come back. That prayer has been rejected, which is why I'm before your Lordship on 2 legal counts. One is now public sector banks have been allowed to issue a lookout circular against a borrower by incorporation of public sector banks in the Office Memorandum of 2021. This has now been declared to be ultra-virus the Constitution. So the authority of public sector banks to issue a lookout circular is declared to be a violative of Article 14 and
By Bombay
21
High-
by Bombay Division Bench judgment. And your Lordships are aware that once there is
Appeal
a.
has been filed against that. But our judgment has not been reversed.
I am also going to be constrained to rely on decisions passed by this honorable court, where it's been held that just because a debt is pending or lookout circulars cannot be issued for recovery action, you will have to show.
No, it's not a recovery action. It is to ensure your presence in the country.
Well, that is
But,
what has been
sir,
held.
admittedly, there's a decree against
There is a decree.
you. File an
Yes,
appeal,
yes.
obtain an interim order.
Well, then the
The only
immediate
option open
requirement
is
to go.
He can participate online. That's it.
Well, could I just indicate one
Because
fact?
actually the
Could I
observation of
just
the
indicate
learned,
one fact? Correct here.
For my son's graduation also, I participated online because I couldn't afford traveling.
Well, your Lordship will just for very different circumstances, my Lord. Not because the father had a LOC issued against him. Here, kindly consider just the legality of the action.
That can't be done. It has to be done in the writ petition.
But it was considered and
Prima-
thereafter rejected.
Prima facie,
Prima facie, your Lordship will find that the learned single judge found favor with what I had argued. There is also an observation that it is true when an action is declared ultra-virus in one court of the country, because it's declared ultra-virus in consideration of the Constitution, it operates across the country, across the territory of the country.
So if their authority has been declared to be ultra virus,
Did the Union of India file an affidavit in your petition?
no, well, this was on the Thursday motion. I am simpliciter on the authority.
Lordship, in the.
May I just indicate 2 minutes? May I just indicate two facts? One is that there is a decree for money cannot be a ground for issuance of LOC, one, for a lookout circular. Second, and a slightly better point in my assessment, is when the authority of a public sector bank to issue a lookout circular has been declared to be ultra virus, then they have no authority any further to
Therefore,
continue.
that issue has to be considered.
Well, the judgment is
whether the judgment of the Honorable Division Bench of the Bombay High Court is of persuasive value or is a binding precedent. Because it is declaring a circular issued by the Union of India as ultra virus.
Yes.
So it will apply pan-India.
That's right.
Your argument. That needs to be considered.
Look, I'll show one judgment of the Supreme Court. No, this is not an Article 141 case. I am not saying this has precedential value. That is in my respectful submission where the learned single judge has possibly erred. This is not a case where I'm saying that this is binding or it has.
But then this LOC was issued long prior.
LOC was issued long prior, but it's still subsisting.
So therefore, that has to be heard, sir.
Look, I am only on the question today that today, prima facie, when the court finds that what I've argued has basis, and once I show that an action by a bank has been declared to be ultra virus, no, this is not an Article 141.
We have interpreted the very same clause. We do not know whether our judgment was placed before the Bombay High Court, whether it was taken note of, and we have interpreted how this will fall within public interest.
Look, that is possibly with the bank.
You have perused that judgment?
No. Well, that is, but I am
also not.
We have not been able to come across.
We have not been able to come across that, Manoj.
Mr. Sabishashi Chaudhary appeared for the bank and he succeeded in the appeal. We reversed the single bench order. I think it is Justice Shampa Sharka's order where LOC was quashed
I will
very same ground.
I will look at it. Look, may I just indicate only one fact? Kindly have a look at paragraph 21 of the Supreme Court judgment, the 22. This is the most oft-cited kusum in God's Manoj. Why this is not about whether it's precedential or it has persuasive value. Kindly have a look at paragraph 22.
Copy Deven, bhai. Director Deven.
Kindly have a look at paragraph
Kindly give me
22. It's a accident. It's a
I'm asking a copy.
Line paragraph. The court must have the requisite territorial jurisdiction. An order passed on the writ petition questioning the constitutionality of a parliamentary act, whether interim or final, keeping in view the provisions contained in clause 2 of 2026 of the Constitution of India, will have effect throughout the territory of India, subject, of course, to the applicability of the act. So your lordship's judgment, in fact, the other judgments also that I'm carrying, are with the repository of power or the source being kept intact, whether this is for recovery is valid or not. Now that repository or the source of power has been declared unconstitutional. So whether this is for public money, whether it's in the economic interest of India, that is possibly a consideration that will follow.
Where is the lookout circular?
Yes, no, the lookout circular is never. This is primarily one of the grounds on which has been declared unconstitutional. On 4 counts, has been declared unconstitutional as ultra virus Article 14 by the Bombay Division.
That will be considered in the writ petition.
Well, that was placed, and your lordship will find in the interim order, learned single judge holds that prima facie I have a
What
case.
date lookout circular was issued?
2022, after the 21 incorporation. So public sector banks were incorporated by an office memorandum of 2021. Your lordship should have seen that.
He was stopped from going below.
I have just said that some
This was the
This
actual observation.
intercourt appeal by the writ petition.
Lord, may I only just pray for this?
Against the order passed by the learned single bench declining to grant an interim order of the lookout circular issued against the appellant in the year 2022. The learned advocate for the appellant would strenuously contend that the Honorable Division Bench of the Bombay High Court, in the case of
I'll share the judgment.
Viraj Chetan Shah versus Union of India and others, 2024 SEC Online Bombay 1195 has declared the amended memorandum issued by the Ministry of Home Affairs as ultra virus. And consequently, the lookout circular issued on the sole ground that a requisition was made by a public sector bank is no longer valid. Admittedly, the lookout circular was issued somewhere in the year 2022. Further, it is an admitted position that there is a decree passed against the appellant writ petitioner by the Debt Recovery Tribunal sometime in April 2024, where the amount payable by the appellant is more than rupees 250 crores. The learned advocate for the appellant placed reliance on the decision of the Honorable Supreme Court in Kusum Incots and Alloys Private Limited versus Union of India, 2004 6 SEC 254, for the proposition that an order passed in a writ petition questioning the constitutionality of a parliamentary act, whether interim or final, keeping in view the provisions contained in clause 2 of Article 226 of the Constitution of India, will have effect throughout the territory of India, subject, of course, to the applicability of the act. In the appellant in the writ petition has challenged the lookout circular, and there is no challenge to the notification issued by the Ministry of by the central government. The notification admittedly is not a parliamentary act. The question would be as to whether the question as to whether the judgment in the case of Vijay Chetan would be a binding precedent or that of a persuasive value is to be considered in the writ petition. And in our view, the learned single bench rightly directed affidavits to be filed, as the Union of India has to be heard in the matter. That apart, this court has also considered the effect of such a circular at the behest of a public sector bank, and given its interpretation that the lookout circular can be issued at the behest of the bank as public interest is involved, since the amount due and payable by the borrower is undoubtedly public funds. Therefore, we are of the view that the learned single bench, therefore we are of the view that the order passed by the learned single bench declining to grant any interim order would not call for interference. The grounds which have been raised by the appellant in this appeal are all grounds which have to be considered in the writ petition, and precisely for the said reason, the learned single bench has observed that the court does not make any conclusive pronouncement as of now, as has been done by the High Court of Bombay, and was of the view that the matter needs deeper consideration after receipt of the affidavits. Therefore, we find no grounds to interfere with the impugned order. Appeal dismissed. Sorry, sir.
Grateful, Lord. Grateful. Grateful, Lord.
Next.
7, my lord, I am appearing on behalf of the appellant, my lord. This is my lord defective. I prepared for 7 days time to cure the defect, my lord.
The learned advocate appearing for the appellant requests 7 days time to cure the defect pointed out by the registry. List the matter next week in the admission list.
Serial number 8.
But I'm appearing for the appellant, my lord. I'm led by Om Narayan sir, my lord. The others.
Your lordship, I'm praying for not today, your lordship. Your lordship, I'm praying for not today.
No, at your request, the matter was listed today.
Yes, your lordship, kindly not today, your lordship. The advocate is not, well, he's not come today, your lordship.
Mr. Soman Datta. At the request of the learned advocate for the respondent. Put it after 2 weeks. or 1 week? Next week.
Serial number 9.
I appear, my lord, for the appeal.
I appear to the writ petitioner respondent.
Lord, fairly, my lord, important, my lord, question for my lord, consumers of electricity, my lord, provided, my lord, by DVC, my lord, in Jharkhand, my lord, is under, my lord, is, my lord, the subject matter really, my lord. Now, my lord, there is a Jharkhand High Court judgment, my lord, which, my lord, interprets, my lord, clause 5.3.3 of the Jharkhand regulations, my lord, with regard to conditions of supply. The supply code, my lord, which was framed under section 50, read with 181, my lord, of the Electricity Act. Now, my lord, our High Court now, my lord, has taken, my lord, a different view. My lord, of, my lord, relating to consumption of electricity in Jharkhand. So, my lord, this is really, my lord, created a problem because now, my lord, the view which has been taken here, my lord, says, my lord, in effect, my lord, that if a consumer, my lord, has past dues, my lord, he sells off, my lord, that, my lord, unit or property and, my lord, goes, then, my lord, the person who is, my lord, coming in his place, my lord, will not have to pay, my lord, the outstanding dues.
But there are certain decisions of Supreme Court which says otherwise.
Correct.
Yes, absolutely, my lord.
No, very recently.
My lord, 9-an's case, my lord.
No, we came across a recent decision of the Honorable Supreme Court, Chief Justice of India.
9-an's case, my lord. I have that. I have that.
That was relating to property tax dues, I think. Several issues were considered.
Yes. Now, my lord, I'll tell your
Having the
lordships.
judgment copy is available.
My lord, I have that here. My lord, that's, my lord, 9-an's case.
That was under SURFACE Act. SURFACE Act.
Surface, no, this is not surface. This is Electricity Act, my lord. My lord, may I, my lord, just indicate, my lord, what, my lord, the point is, my lord, and then I'll take your lordships, my lord, through. My lord, it is settled, my lord, proposition of law that, my lord, in common law, my lord, if, my lord, anything, my lord, is outstanding, it does not constitute a charge on the land. My lord, that has, my lord, been, my lord, the legal position right through, recognized by the Supreme Court, my lord, all along. My lord, after the 2003 Act, my lord, the provisions which have been made, my lord, in the Act, and the power given, my lord, for, my lord, subordinate legislation as to provide for conditions of service, the Supreme Court has recognized, my lord, that, my lord, the relevant regulations, my lord, can make provision, my lord, to the effect that, my lord, past dues, my lord, have to be paid, my lord, for, my lord, the purposes of seeking, my lord, a new connection on the same premises. Third thing, my lord, the question that arises here is, my lord, did the Jharkhand Supply Court make such a provision? Fourth, my lord, the Jharkhand High Court has said, yes, it does. Now, my lord, the writ petitioner was a consumer of electricity in Jharkhand. My lord, he comes, my lord, I'm not saying High Court didn't have jurisdiction. My lord, could have, my lord.
Because his registered office is in.
Correct, DVC registered office could have. Now, our High Court, my lord, has held, my lord, exactly to the contrary. My lord, though, my lord, Jharkhand judgment was cited, my lord has not agreed with it, and my lord has.
The division bench judgment.
No, my lord, Jharkhand High Court was, my lord, by a learned single judge. My lord, it was set aside by the division bench, not on, my lord, the ground which is, my lord, the subject matter here, but on the ground, my lord, that that regulation could not have retrospective operation. My lord, this is, my lord, in short, my lord, the issue. Now, may I, my lord, just show your lordships, my lord, two statutory provisions of the Electricity Act, and, my lord, the regulations. And then, my lord, I'll come, my lord, to the judgment. Now, my lord, the Electricity Act. My lord, I have 2 copies, my lord, of the Electricity Act.
No, we have got.
My lord, kindly take, my lord, section 43. My lord, subsection 1. Save as otherwise provided in this act, every distribution licensee shall, on an application by the owner or occupier of any premises, give supply of electricity to such premises within 1 month after receipt of the application requiring such supply. Then, my lord, kindly come to the explanation straight away, my lord. Because subsection 1 uses the expression application. Now, my lord, the explanation says what is an application. For the purposes of this subsection, application means the application, now kindly note this, complete in all respects in the appropriate form as required by the distribution licensee. And, my lord, the next is also important, along with document showing payment of necessary charges and other compliances. My lord, kindly note this, my lord. So, my lord, this obligation, my lord, under section 43, my lord, is, my lord, to provide, my lord, supply of electricity on an application. And, my lord, for the purposes, this duty, my lord, which is cast, my lord, on the distribution licensee, my lord, says, my lord, that for, my lord, this duty, my lord, to be, my lord, discharged, my lord, the application has to be complete in all respects, in the appropriate form, as required by the distribution licensee, along with documents showing payment of necessary charges and other. This, my lord, unless this is fulfilled, there is no application, my lord, before, my lord. Yes. Now, my lord, kindly have a look at section 51 and, my lord, section 181. My lord, the State Commission shall specify an electricity supply code to provide for, now kindly note this, recovery of electricity charges, intervals for billing of electricity charges, disconnection of supply of electricity for non-payment thereof, restoration of supply of electricity, measures for preventing tampering, distress or damage to electrical plant or electrical line or meter, entry of distribution licensee or any person acting on his behalf for disconnecting supply and removing the meter, entry for replacing, altering or maintaining electric lines or electric plants and such other. So, my lord, what I wish to emphasize on, my lord, can provide for recovery of, my lord, electricity charges. Now, my lord, kindly come to 181, my lord. My lord, 181, the State Commission may by notification make regulations consistent with this act and the rules generally to carry out the provisions of this act. Now, my lord, subsection 2, in particular, and without prejudice to the generality of the power contained in subsection 1, such regulations may provide for all or any of the following matters. Namely, kindly come to, my lord, X, my lord, electricity, my lord, kindly see, electricity supply code under section 50. Lordship has that, my lord. So this is, my lord, part of the scheme of the act. My lord, supply code can provide for recovery, and, my lord, regulations, my lord, can, my lord, provide for this. Now, my lord, here, my lord, 2 facts, my lord, are important. My lord, the regulations which are, my lord, being relied on, my lord, by DVC are of 2015. Now, my lord, the new owner, my lord, obtained, my lord, title in 2019 when the regulations were in force. So, my lord, the issue of, my lord, retrospective operation is not involved here at all. My lord, this is squarely, my lord, within, my lord, the period that, my lord, these regulations, my lord, were in force. Now, my lord, may I cite, my lord, first the Supreme Court judgment, then I'll come to the regulations, their interpretation by, my lord, the Jharkhand High Court. Now, my lord, kindly come to, my lord, Ninan's judgment, my lord, which is, my lord, my lord, this is reported in 2023. Online, এটাই তো।
Yes, sir.
My lord, this is, my lord, 2023 SCC online SC 663. My lord, I hope your lordships have, my lord, that. My lord, kindly come straight away, my lord, to, my lord, paragraph 33, my lord. Lordship has that, my lord, para 33. And this is, my lord, what is important. In Brihan, Mumbai, Electric Supply and Transport Undertaking versus Maharashtra Electricity Regulatory Commission, a two-judge bench of this court observed that the obligation of the distribution licensee to supply electricity to premises, kindly mark the words, my lord, will begin after the owner or occupier of such premises submits a completed application. The explanation to section 43 clarifies that the application must be complete in all respects, along with the necessary documents showing payment of necessary charges and other compliances as required by the distribution licensee. Thus, under section 43, the distribution licensee is obligated to supply electricity to the premises of an owner or occupier, provided that the owner or occupier pays all charges and complies with all conditions stipulated by the distribution licensee. Section 43 begins with the words, save as otherwise provided in this act. Hence, the operation of section 43 will also be subject to compliance with the other provisions of the 2003 Act. And my lord, your lordships, aware, my lord, I'm not going to trouble your lordships. My lord, delegated legislation validly made, my lord, forms part, my lord, of the statute itself. Now, my lord, kindly come to, my lord, paragraph 75. My lord, really 75 to 89, but I will not place all, my lord. I will just, my lord, just traces the history, my lord, of, my lord, the 2010 Act. Then, my lord, we had, my lord, more modern electricity legislations in some states, my lord, particularly Odisha. Now, my lord, kindly come to para 78, my lord. We are, sorry, my lord, at page, my lord, PDF page 32, I think. We are of the opinion that the reasoning of this court in India Thermal actually supports the arguments of the electricity utilities. As evinced by Hyderabad Vanaspati, the conditions of supply enacted by the boards have a statutory character. Therefore, any condition enacted under section 49 of the 1948 Act, specifically one requiring the new owner to clear the arrears of the previous owner as a precondition to availing electricity supply, will have a statutory character. When such a condition is incorporated as part of a contract, such contract also attains a statutory character, and the liability contained therein becomes a statutory liability which can be enforced by utilities against third parties, including new owners. The next question that comes up for consideration is whether the electricity utilities can enact a condition providing for recoupment of electricity arrears of a previous owner from the new owner. under the 1940 Act, the board could enact terms and conditions for supply under 49 read with. This court has held on many occasions that the term regulate is to be given a wide interpretation, allowing performance of everything necessary for organized implementation and conduct of business. In Deepak Theatre, so on, 3-judge bench, etc. Then, my lord, now kindly come to, my lord, paragraph 81. In the next page, my lord. The above analysis must guide the interpretation of section 49 read with 79J, which impart the board to enact such terms. This power of the board would extend to enacting conditions providing for recovery of dues of erstwhile owner from new owner as a precondition for supply of electricity. Further, this court has consistently upheld the conditions of supply. Kindly mark, my lord, the expression conditions of supply, providing for recoupment of arrears of a previous owner from the new owner as a precondition for supply of electricity. A 2-judge bench of this court in so and so, while summarizing the position of law laid down in Paramount and Paschim Anchal Vidyut Mitra, etc., observed that the supply can recover the arrears of electricity dues of previous owner or occupier from purchaser if the statutory rules or terms and conditions of supply, which are statutory in character, authorize the same. So, my lord, here, my lord, the statutory provision, my lord, is made by the code. My lord, read with, my lord, section 50, read with 181, and my lord, the first paragraph I read, para 33. Now, my lord, kindly come to, my lord, paragraph, my lord, 85. And my lord, I must tell your lordships, at the first instance, I'm not putting my case, my lord, I'm first putting my case, my lord, on a simple, my lord, basis that, my lord, for a writ of mandamus to be issued to me, my lord, there had to be a proper application in place. If that was not, my lord, then, my lord, no. And in any event, my lord, this demand, my lord, which I make, my lord, was authorized, my lord, under, my lord, the regulations. Now, my lord, kindly come to, my lord, paragraph, my lord, 85(1), section 50. My lord, this is the 2003 Act. My lord, 84, I'm not troubling. My lord, that's the definition of electricity supply code. Now, my lord, your lordship will find, my lord, here also, my lord, recovery, my lord, has been highlighted in the set out portion, my lord, at para 84, my lord, of the judgment. I don't know, my lord, if your lordships are.
Yes.
Then para 85, section 50 of the 2003 Act specifies State Commission can specify, etc. Define State Commission so and so. State Commission is authorized to notify use of expression such as recovery of electricity charges, disconnection of supply, restoration of supply under 50 indicate that the scope of the regulatory powers of the State Commission under the provision is wide enough to govern all matters relating to supply of electricity in the premises. 2003 Act lays down the legislative framework for generation, transmission, distribution, trading, and use of. In the process, Parliament has also conferred discretion on regulatory authorities, particularly Central Commission State, to work out further details within the framework of the legislative policy laid down in the legislation. While making subordinate legislation, the delegated authority has to act within the confines of plenary rules or regulations enacted by central or cannot override 2000 by stipulating inconsistent. To the impasse to make so-and-so, PTC so-and-so, Constitution bench held that regulations can be framed as so long as they satisfy the conditions. First, must be consistent. Second, they must be for carrying out the provisions of the Act. Objects. Now, my lord, kindly come straight away to, my lord, paragraph, my lord, 89.
Well, I must make it clear, my lord, I am not disputing this proposition. What my learned friend is submitting, my lord, that regulatory provisions can be made for recovery. I am not disputing that proposition at all.
That's why, my lord, I want to, my lord, show, my lord, paragraph 89, my lord, kindly, my lord, take the next page, my lord, last, my lord, 5 lines. Therefore, a condition enabling the distribution licensee to insist on the clearance of arrears of electricity dues of previous consumer before resuming electricity supply is valid and permissible. Then, my lord, the next question that arises for whether a regulation providing for recouping the arrears from the subsidy has a reasonable nexus with the provisions of the 2003 Act. And my lord, now para 91, my lord, is my lord very important, because my lord, any interpretation, my lord, of my lord, the act and the regulations framed thereat has to follow this, because the Supreme Court recognized, my lord, why, my lord, if I may, my lord, put it, my lord, in question form. My lord, why did we need, my lord, the Electricity Supply Act? Because, my lord, all the state undertakings which were responsible for generation, distribution, transmission, my lord, were collapsing. My lord, they were not in a position, my lord, to, my lord, discharge, my lord, their public functions. So, my lord, protection of these utilities, my lord, was, my lord, one of the conditions, my lord, which was, my lord, in mind. And that is exactly what the Supreme Court says, my lord, in para 91. The 2003 Act has been enacted to promote the development of the electricity industry, as well as to protect the interest of the consumers and to ensure the supply of electricity to all areas. The supply conditions providing for recoupment of electricity dues of a previous consumer from a new owner necessary to recover the costs incurred for laying down the infrastructure, as well as the ongoing current liabilities towards electricity generation and transmission. In the absence of such conditions, it may be difficult for the distribution licensees to recover defaulted payments, adding to revenue deficits. This may adversely impact the financial health of distribution licensees to the detriment of the interest of the consumers. Now, my lord, kindly have a look, my lord, at, my lord, the regulations which are, my lord, involved here. My lord, kindly take, my lord, page 195. My lord, these are, my lord, the Jharkhand Regulatory Commission, my lord, Electricity Supply Code. My lord, kindly see 2.3. That page, my lord, 198.
Yes.
In these regulations, unless the context otherwise requires, my lord, kindly see D, my lord, 2.3D. Applicant means an owner or occupier of any land premises who files an application form. Kindly mark the expression application form with a licensee for supply of electricity. My lord, increase or reduction in sanctioned load contract, change in title, disconnection or restoration of supply, or termination of agreement, as the case may be, in accordance with the provisions of the Act and the Code. Act is the Electricity Act, Code is this, rules and regulations made thereunder and other services. Then, my lord, application means an application form, complete in all respects in appropriate format as required, so and so, along with documents showing payment of necessary charges and other compliances. And then, my lord, it's the language, my lord, of, my lord, 4.3, my lord, explanation,
4.3.
which is 43 explanation. Then application form means an application form complete in all respects in appropriate format as required by distribution licensee before any payment of applicable charges. Then, my lord, kindly come to, my lord, regulation 5.5. My lord, kindly see the heading, my lord, of 5. That's page 207. One minute, heading I'm showing first. My lord, kindly see A5. My lord, requisition for supply. Lordships have that. Now, my lord, 5.1. Kindly see the licensee's obligation. The distribution licensee shall, on an application by the owner or occupier of any premises located in his area of supply, give supply of electricity to such premises within the time specified in these regulations, provided supply of power is technically feasible. Then, my lord, B is what is important here. The applicant has observed the procedure specified in these regulations. Then, my lord, kindly come to 5.3 at page 208. My lord, conditions for grant of connection. Now, my lord, kindly note. So, my lord, it's a condition of supply. Now, my lord, purchase of existing property is 5.3.3, which is, my lord, the most important regulation, my lord, involved here. Where the applicant has purchased an existing property whose electricity connection has been disconnected, it, kindly mark this one, it shall be the applicant's duty to verify that the previous owner has paid all dues to the distribution licensee and obtained a no dues certificate from him. Now, my lord, a duty is cast, my lord, on, my lord, the purchaser to, my lord, verify, my lord, whether a no dues certificate has been obtained or not. Then, my lord, in case such no dues certificate has not been obtained by the previous owner before change in ownership of property, the new owner may approach the distribution licensee for such a certificate. Then, my lord, the distribution licensee shall acknowledge receipt of such request. Kindly mark the expression, receipt of such request, and shall either intimate in writing the dues outstanding on the premises of any, or issue a no dues certificate within 1 month from the date of receipt of such application. Now, the application here is a request for, my lord, the no dues certificate, provided the previous owner has not got it. This is a request, my lord, which is to be made, my lord, for, my lord, a no dues certificate, and 1 month's time is given, my lord, to respond. Now, my lord, kindly come to the next sentence. In case the distribution licensee does not intimate the outstanding dues or issue a no dues certificate within this time, now kindly note this, new connection to the premises shall not be denied on grounds of outstanding dues of the previous consumer. In such an event, the distribution licensee shall have to recover his dues from previous consumer as per provisions of law. So, my lord, in my respectful submission, this provision, which is a condition for, my lord, supply, and, my lord, before, my lord, grant of connection, my lord, if a no due certificate is not there, my lord, from, my lord, the previous owner, my lord, the person applying for this connection has to apply, my lord, for a new no due certificate. And, my lord, if within 1 month, my lord, of such an application, either the dues are not intimated, or, my lord, it is, my lord, held that there are found that there are no dues, my lord, then, my lord, cannot refuse, my lord, connection, my lord, on the ground that something is due and payable. And, my lord, the distribution licensee has to go, my lord, to, my lord, the previous owner for, my lord, recovery. Now, my lord, before I place the judgment, I just want to give your lordships a flavor, my lord, of, my lord, the impugned judgment. My lord, this provision, my lord, has been held to be totally, my lord, 3 things. My lord, the expression application here, my lord, has been construed to mean, my lord, the application for, my lord, connection, and not a request, my lord, for, my lord, a no due certificate, which I think, my lord, is, with the greatest of respect, my lord, the first error. Second, my lord, it has held that, my lord, the expression, my lord, that this provision, my lord, as far as the new applicant is concerned, my lord, is directory. So if he does not, may. But, my lord, I have 2 points apropos that, which I shall deal. My lord, the entire regulation has to be looked. My lord, may, my lord, cannot, my lord, govern. My lord, the alone, my lord, the entire provision, my lord, has to be looked at. My lord, the first is, my lord, there is, my lord, a duty to verify.
Whether he has obtained a notice.
Yes, there is a duty to verify. And secondly, my lord, there was no need for a default, my lord, provision that if in 1 month this request is, my lord, not responded to, my lord, there will not be any embargo on obtaining a new connection without payment of outside. No need. If it was not mandatory. And third, my lord, in making this interpretation, my lord, the learned judge, my lord, with the greatest of respect, had to consider, my lord, the purpose of the new act and the regulations framed thereunder, which was, my lord, it has to inure, my lord, to the benefit of, my lord, both utility and the consumers. And that is, my lord, that paragraph of the Supreme Court judgment which I read, my lord, to your lordships, my lord, which was paragraph 91. And, my lord, that is also what the Jharkhand High Court has relied on in, my lord, saying, my lord, that 5.3.3, my lord, is, my lord, a stage which has to be undergone before the application as per section 43 and as per the regulations for supply can be considered. Because it has to be complete in all forms. One of them is a no-due certificate, a document. Now, my lord, the learned judge has said that clause 6.10 of these regulations, my lord, override 5.3.3 and are our only relevant regulation.
.10,
my lord, that your lordships will find at, my lord, page 215.
Yes.
My lord, kindly just give me a moment. Now, my lord, kindly come before that, my lord, to page 213 once. My lord, the heading is A6, my lord, kindly see. Procedure for providing fresh electricity connection. Then, my lord, it shall be the duty of the distribution licensee to issue a duly authorized acknowledgement of each application form accepted or inform an applicant upon request of the status of his applications and reasons, if any, for non-disposal, etc., etc. Now, my lord, kindly come to 6.4 at page 214. My lord, kindly see the itemized portion as well, because they have to relate back to the definition and section 43. An application form shall be deemed to be received on the date of receipt of consumer's requisition of supply in the prescribed format of the application form, complete in all respects and attached with all relevant documents. Now, my lord, 5.3.3, my lord, no due certificate, or, my lord, a refusal, my lord, or inaction on the part of, my lord, the distribution licensee to respond 1 month, my lord, in 1 month, my lord, are, my lord, the relevant documents which have to be there with the application form. Then, my lord, kindly see. An application shall be deemed to be received on the date of receipt of all applicable charges, including the security deposit, in accordance with Annexure 18 of these regulations, after receipt of the application form. Now, my lord, kindly come to, my lord, 6.6 is inspection, etc. My lord, so, my lord, this is happening, my lord, after a valid application form. Now, my lord, kindly come to 6.10. During the inspection, the distribution licensee, my lord, and this is what has been relied on, my lord, by the learned judge, verify that there is no outstanding due in the applicant's name, the applicant itself, or for the premise for which the new connection is being applied for. If the applicant in respect of an earlier agreement executed in his name or in the name of a firm or company with which he was associated either as a partner, director or managing director has any arrears of electricity dues or other dues for the premises where the new connection is applied for and such dues are payable to the licensee, the requisition for supply may not be entertained by the licensee until the dues are paid in full. Now, my lord, I pause here. My lord, this is, my lord, after we have a completed application form, my lord, during inspection, my lord, it turns out, my lord, that the applicant or an entity in which he is associated, my lord, had, my lord, outstanding dues. My lord, it need not be entertained irrespective of what 5.3.3 states. So, my lord, even if he's got the benefit, my lord, of a non-response, my lord, within that 1 month period, but it's found, look, he's actually the culprit. We have overlooked something. My lord, they can say, sorry, we are not going to process this. Now, my lord, the next one. But if the erstwhile consumer defaulted payment of dues and left the premises for good, and the concerned premises has come in legal possession or of a new occupant through transfer or decree stroke order of the court authority, and who has no nexus with the previous owner occupant in any manner, applies for connection of the electrical line in the same disconnected premises, the distribution licensee shall provide electrical connection without realization of the arrear dues of the premises payable by the erstwhile consumer from the subsequent transferee of the premises, and he shall not be held liable to pay discharge the liability for securing. Now, my lord, here again, my lord, my respectful submission is, this is a situation happening after, my lord, a fully complete application form, my lord, with all relevant documents. If the distribution licensee, my lord, has, my lord, not responded to the application for a no due certificate, then, my lord, on inspection, there is a no due certificate, and on inspection it is found, sorry, there's something due and payable. My lord, he cannot, my lord, if the transferee has no nexus, my lord, with, my lord, the, my lord, erstwhile, my lord, consumer, my lord, refuse to provide, my lord, an electricity connection. Now, my lord, the learned judge, my lord, has held, instead 5.3.3 is, my lord, not mandatory, it's, my lord, directory, and, my lord, 6.10 is all that needs to be looked at. And with the greatest of respect, my lord, that is contrary, my lord, to, my lord, the norms, my lord, which should have been applied in interpreting, my lord, these regulations. As also now I'll show your lordship, my lord, the Jharkhand High Court judgment, my lord, dealing, my lord, with this. My lord, this is, my lord, yes. Yes, my lord, this first the learned single judge, and then, my lord, my lord, kindly come to para 29, which is, my lord, my lord, in this decision, my lord, the vires of clause 5.3.3 of the regulations were challenged. Apart from anything else. And my lord, the second, my lord, was, my lord, it was contended that because of 5.3.3, my lord, the past dues, my lord, could not be recovered from, my lord, the transferee. Kindly, my lord, come to para 27. My lord, at, my lord, PDF page 6, my lord. Lordships have that, my lord? Yeah. By virtue of the provisions as contained in the supply code is to be formulated, etc., which confers power. In pursuance of the aforesaid provision, regulation as contained under so-and-so has been enacted by making a provision of getting no dues from subject to enclose the certificate along with application if filed for granting. Basic purpose of the said regulation is that the licensee may not be allowed to be put at loss due to fault committed on the part of the erstwhile owner of the premises. My lord, if licensee commits, my lord, a fault, my lord, he is penalized under 6.10 unless those conditions, my lord, are met. Like, my lord, a wrong no dues certificate or not responding, my lord, and inspection throws up something else. Then, my lord, kindly come to, my lord, paragraph 36, my lord. My lord, in fact, 35 onwards I should read. Kindly come to para 35. My lord, print page 7. As has been, I'm sorry, my lord, as has been referred herein above, the need for enactment of a new act in the year 2003 has been felt in the background of the facts that the performance of the state electricity boards deteriorated on account of various factors, including their inability to take decision on tariff in a professional and independent manner. The Electricity Act contains the provision of section 186 that against provisional and final assessment and appeal is to be an alternative mode by constituting a forum for adjudicating dispute arising. It has been provided by way of consumers and so supply code has been formulated in view of Electricity Act 2003. Thus, the basic purpose for enactment of the Electricity Act 2003 is to allow the licensee to survive. The survival is on the ground by putting effective measures in making recovery of the amount which is to be paid by the consumers. The supply code has taken care of with respect to this particular aspect of the matter by coming out with a provision as contained under regulation 5.3.3 of the supply code of the year 2015, since the same was not available in the supply code of the year 2004. The basic purpose is to recover the amount which is to be paid by the consumers on account of consuming the electricity, even the consumption if made by the erstwhile occupier or owner of the premises in question. The basic object for enactment of the provision as contained in so-and-so is to recover the amount which is to be paid by the consumer who has used the electricity. Therefore, the said provision is strictly to achieve the object and aim of it. It is for this reason that if the erstwhile owner who has used the electricity is selling it out in favor of the subsequent purchaser, who in case of making an application for getting fresh electricity connection, if not required to make payment for use of electricity by erstwhile consumer upon the premises, it will nothing but accelerate the loss to the licensee. And if that would be allowed to be done, the basic object of enactment of Electricity Act will frustrate and no purpose would be served in the decision taken by legislature in repealment of the earlier statutory provisions which has been superseded by virtue of the Electricity Act 2003. The petitioner has questioned the aforesaid. My lord, that is on the viris. My lord, all my lord, the cases, my lord, were my lord considered. And the court, my lord, upheld it. Now, my lord, the division bench judgment, and I want to show your lordships this, and my lord also accepted by the learned judge. My lord does not deal with, my lord, the interpretation of 5.3.3, but my lord, retrospective application of it. And therefore, my lord, this was not touched, this issue. My lord, kindly take, my lord, the division bench judge. Indemnification provision. My lord, kindly see, my lord. My lord, paragraph, my lord, there was another, my lord's learned single judge, my lord, decision which had not been noticed with regard to retrospective application. Now, my lord, that is referred to, my lord, paragraph 20, 21 and 22. My lord, your lordships will find. My lord, para 20, 5 lines from the top, my lord. PDF page 70. My lord, 5th line from the top of para 20. My lord, sentence starting at the time. Lordship said, sale of property to the appellant on so-and-so, no such notice was served upon vendor certificate under clause point so-and-so of Electricity Supply Code 2000 being statutory in character. Electricity could not be denied to new occupant or purchaser coming in legal possession through transfer of purchase, even if there were arrears due and if there was no connection of the incumbent with previous owner, occupant or nexus. The appellant purchaser was under no obligation to obtain no dues certificate from previous owner or verify whether he had paid all dues before change in ownership, as clause was not in existence at the time of purchase. Electricity was brought into force with effect from so-and-so. Then, my lord,
So the purchase was in 2011.
11, before, my lord, 2000, and on that ground only, my lord, on interpretation, my lord, of 5.3.3. Now, my lord,
Here the purchaser is,
2019.
no, it is not through bank auction or something.
No, my lord, if e-auction, my lord, your lordship's aware.
Here it is pursuant to the Orissa public.
Correct. My lord, your lordships would recall, bank auction, my lord, were the first line of cases. My lord, where, my lord, they said, my lord, that, my lord, if the auction notice, my lord, provides that arrears also have to be cleared, my lord.
Dealt with that in one matter.
Yes, my lord, that is, my lord,
Appeared.
here, of course, my lord, rather,
That is surface procedure.
yes, my lord, here, of course, my lord, it is more. My lord, it's a statutory provision. Of course, my lord, your lordship.
But that's why the division bench says he had no nexus with the
That is
previous owner.
6.10. My lord, if he still had nexus, my lord, that was, my lord, and which provision was there earlier? My lord, that's really defrauding the regulations, owing to a mistake.
So primarily on 2 grounds they succeeded. One is that
6.10 is, my lord, overrides
Overrides
5.3.3 and 5.3.3 is discretionary.
Discretionary, not mandated.
Directory, my lord, provision.
Directory.
My lord, I made the mistake. I said discretion. My lord, directory, my lord, and my lord, not mandatory. And my lord, the subsidiary point to that is, my lord, the expression, my lord, application referred to in 5.3.3 is the request, my lord, for, not, my lord, the application for, my lord, supply of electricity. Because the information which has to be furnished is whether you have a no due certificate.
What was impugned in the writ petition?
My lord, I'll show your lordship, my lord. Kindly have a look, my lord, at, my lord, the prayers ones.
Page 41.
Yes, my lord. And my lord, the document by which this demand was made. My lord, page 41 are the prayers.
And the impugned order, impugned communication.
Yes. My lord, kindly see, my lord. Recall, rescind and withdraw the letter dated 29 November.
That is at page 173.
Correct.
173.
My lord, kindly, my lord, take, my lord, 29 November 2022 regarding connection of so-and-so. This has reference to your application for connection premises. In this regard, Saluja Steel is requested to make following payments which are outstanding prior to initiation of the power supply connection process. My lord, pay these sums. And my lord, 30th November, my lord, kindly come to page 174. Praise to the
So 27.9. So what page 166? So they have
And my lord, at page 176, my lord, this is 30th November. My lord, it's a 3-page document. My lord, note 8.
Page
173 it starts.
Yes.
30th November, my lord. And kindly come to, my lord, page 176. My lord, this refers to the 29th November letter, my lord. The premises, clause 8, my lord, 176. The premises on which new supply has been applied for belong to so-and-so, who is a disconnected consumer. So-and-so, a separate letter to clear outstanding dues of so-and-so has already been sent to you, vide letter dated 29 November. That is, my lord, the page 172, which is, my lord, under 173, which is under challenge.
The application is at page 167.
161, my lord, I think. 166.
166.
Yes.
Because in 173, the date is given as 28 September. Actually, it is, I think, uploaded on 27th.
20, yes, my lord, it's
Or dated 27th.
My lord, it's dated 27.
Probably uploaded on 28.
Possibly. Yes. My lord. Yes. Because it's referred to as an application, my lord, of 28 September. My lord, the document itself is so, my lord, possibly, my lord, uploading is this.
Online application.
Correct, I got. So uploaded on the.
Upload করেছিল বোধহয় এটা।
the function of the application is not in the format required by the regulation.
Now, my lord, I'll just place the judgment, my lord, relevant portions of it. My lord, if I may just, my lord, give your lordships, my lord, the points. My lord, 5.3.3.
Yes.
My lord, has been, my lord, as far as, my lord, the distributions, as far as the transferee's obligation, my lord, who, my lord, apply for a no due certificate is concerned, it has been held that that provision is directory. My lord, I'm not giving the grounds of challenge now, directory. Therefore, 5.3.3 whether complied with or not makes no difference. My lord, that is number one. Number two, my lord, is that, my lord, the application appearing, my lord, in the expression application appearing in 5.3.3 has been construed to mean the application, my lord, for the connection itself. Third, my lord, is, my lord, 6.10 is the only provision, my lord, which applies, my lord, with regard to, my lord, making, my lord, providing for a bar, my lord, to a new connection being granted, my lord, to a transferee. Is the only provision.
But the application is for securing a new connection.
Yes, my lord, it has to be, because, my lord, now,
yes.
my lord, Supreme Court has said, my lord, that these are new connections, my lord.
So, for application is concerned, it probably the annexures which have to be along with the application. So, according to the appellant, one of the requirement is a no use.
Yes. My lord, that is, so, my lord, as I said, I put my case, my lord, on two. My lord, the first is, my lord, for, my lord, an application to be considered. My lord, for, my lord, a writ, my lord, a mandamus to be issued. My lord, the application had to be complete in all respects.
Regulation was not under challenge.
Not under challenge. Regulation not under challenge.
You just show us the relevant paragraphs of
Yes,
the
my lord. Kindly, my lord, take, my lord, the impugned order. My lord, why I, my lord, place some of the paragraphs, because some of the argument, my lord, this exact argument, my lord, that this was not, my lord, before application, my lord, this is what needed to be considered, my lord, has not been considered at all. Now, my lord, kindly come to my lord, paragraph. Yes, ma'am. My lord, kindly take it from the memo of appeal, my lord. My lord, paragraph, my lord, 23, my lord. By placing reliance on the expression no due certificate issued in so-and-so, it is submitted that in the absence of any verification from the previous owner, it is the incumbent duty of the purchaser applicant to obtain a new due. Such provision is a precondition for the next portion of the clause to follow. Only if the licensee does not intimate the outstanding dues or issues a no due certificate within 1 month, by the question of non-denial of new electricity and recovery. In the present case, since no application was filed in the first place for obtaining such a certificate from the licensee, the petitioners are not entitled to it. So, my lord, there's no completed application. My lord, that's section 43 as well as the regulations. Then, my lord, kindly see 25. It is next contended that 5.3.3 and 6.10 operate at different stages of the application for new connection. Whereas the no due certificate has to be produced under 5.3.3 at the juncture when the application for new connection is itself filed, that is the first stage of filing the application, clause 6.10 is attracted at the second stage of verification of such application. Learned Counsel places reliance on the respective languages. It says, since the petitioners fail to cross the first hurdle of compliance with prerequisites for filing the application, the question of applicability does not apply at all. So, my lord, the point I wish to make here is, my lord, these two arguments, my lord, are not considered at all. Then, my lord, kindly come to para 30. My lord, at page 8, para 30. Learned Counsel for DVC, in support of his contentions, places reliance on a single bench judgment of Jharkhand High Court reported at so-and-so. Although a division bench of the same High Court subsequently reversed the judgment of learned single judge, such reversal was only on the point of alleged retrospective operation of so-and-so. Then, my lord, kindly come to, my lord, para 33. My lord, that's where, my lord, the, my lord, findings start from. My lord, these are, my lord, the cases were dealt with. My lord, one line of cases which were all, my lord, auction purchase cases. Then, my lord, kindly come straight away, my lord, para 41. My lord, at page 11. However, the present case does not deal with an auction where e-auction mentioned the existence of electricity dues, a direct enacted through sale deeds in the present clearly relieved the purchaser of liabilities, even if left by the erstwhile owner, and also stipulated that property was unencumbered. Thus, there was no way for the petitioners to know about such alleged liabilities. Moreover, in the present case, interplay of 5.3.3 and clause 6.10 of 2015 has to be looked into. Now, my lord, kindly come to, my lord, paragraph 44.
Yes.
On the other hand, the learned single judge of Jharkhand High Court held in so-and-so adjudicated specifically on the legality of 5.3.3. In such context, court held so-and-so cannot be said to be, rather it has been held to be in consonance with object and aim of. Therefore, the court did not interfere. Then, my lord, although a division bench of Jharkhand High Court overruled, the same was restricted to point of retrospective. In the said case, relevant claim was made for a period prior to her. However, in the present case, so-and-so, etc. As such, in the absence of any issue of division bench judgment does not affect the applicability of the ratio of learned single judge, which specifically upheld. Now, with the greatest of respect, kindly note, my lord, the interpretation. My lord, when interpreting 5.3.3, what was held, my lord, by the Jharkhand High Court. My lord, because these regulations, my lord, only apply to consumers, my lord, of electricity in Jharkhand. It's not, my lord, where DVC is the only supplier. There could be other suppliers. This regulatory commission, my lord, supply code, my lord, applies to all, my lord, suppliers. And, my lord, why was 5.3.3, my lord? What was the purpose of it has been held, my lord, by the Jharkhand High Court to protect, my lord, that's not considered at all. Then, my lord, 48. Kindly see page 14, my lord, para 48. A perusal of clause 5.3.3 shows that the same applies at the juncture of filing of an application for getting new electricity. The greatest of respect, my lord, this is prior to the application under the regulations, because this has to form part of the application. Now, my lord, para 50. How, my lord, 52, my lord, 52, my lord, why it is directory. However, it is relevant to mention that the expression used in clause so-and-so in respect of new owner approaching distribution licensee is the directory term may as opposed to the mandatory shall. Hence, it is per se evident that the option is not mandatory but directory. Now, my lord, I pause here. My lord, first, my lord, it's one sentence. My lord, it ignores, my lord, what precedes as well as what follows. Because what it preceded by duty to, my lord, obtain. And second, my lord, is that, my lord, if there is no response within 1 month, then there can be no recovery. There was no need for it. If it was, my lord, just a formality. So you didn't need to apply. You could apply without a no due certificate. And I'll show your lordships, my lord, the statutory form. It requires, my lord, the dues to be mentioned. Then, my lord, next, my lord, para 52. That apart, there is no sanction provided in 5.3.3 in case of default of obtaining such, which renders the said provision all the more directory. So, my lord, according to the learned judge, my lord, there ought to have been a penalty, my lord, for non-compliance. My lord, with the greatest of respect, the provision itself shows that, my lord, if you don't have it, you cannot even make an application. This is not a universal test, my lord, to check whether a provision, my lord, is mandatory or not. That there has to be a, my lord, statutory provision, my lord, imposing, my lord, a consequence. Consequence of in the nature of a penalty. Consequence is provided. The application is incomplete. Regulations themselves say it has to be, my lord, complete in all respects, my lord, with all necessary documents. Then, my lord, kindly now, my lord, this is, my lord, with the greatest of respect, my lord, is, my lord, completely wrong. Para 53. In the present case, in any event, The licensee itself did not insist upon such due certificate while accepting the application and thereby waived their right to raise an objection thereto subsequently. My lord, waiver, my lord, without pleading, waiver on the first date of, my lord, hearing before affidavits, and my lord, waiver to a statutory, my lord, provision, my lord, unheard of, my lord, with the greatest of respect. My lord, entire object, my lord, of, my lord, the new act and the regulations framed by the various state commissions to protect, my lord, the interests of, my lord, the distribution licensees will be defeated. Now, my lord, kindly come to paragraph 54. Clause 6.10 of the 2015 regulations, as rightly contended by the licensee itself, applies to the subsequent stage of verification of the application for new connection. It is precisely at such stage that DVC claims to have discovered that there were outstanding dues left by the erstwhile consumer in respect of the same. And I've said I cannot initiate the process after I realize that. You pay. I'm not doing it under 6.10 because actually you didn't have an application in place. And your lordship seen the application 162, my lord, it has nothing of this. Nothing. Where the supply is required. Now, my lord, I want to show your lordship, my lord, these statutory form.
Page 269.
Yes, my lord, 271, my lord, if your lordships, my lord, kindly take.
What is 269?
My lord, no, 269, my lord, I think, my lord.
Clause 12, 13.
Kind of what? My lord, off. My lord, that's for low tension. This is high tension. My lord, 271.
Clause 22, 23.
Yes, I'm grateful.
So they said no in this.
No, this is not the form which they filed.
They made only a.
Yes, my lord, this is, my lord, kindly see their form, my lord, which is at page 166. My lord, dated 27th, uploaded on 28th. My lord, 167. My lord, kindly see the application form. Nothing. Because 22, 23, 24 is to see whether there's a new due certificate or not. Because
what is this format which they have uploaded?
My lord, these were old formats, my lord, which were there, my lord, which they have applied. But there, my lord, as per the 2003 statute, my lord, there has to be, my lord, an application form complete in all respect, as provided.
Yes.
Now, my lord, what is, my lord, I'll just, my lord, summarize my points, my lord. First is, my lord, error, my lord, in holding, my lord, that 5.3.3, my lord, is, my lord, directory. My lord, three things, my lord, have been, my lord, to arrive at this, my lord, three, my lord, four errors, my lord, have been, my lord, committed. One is, my lord, by reason of the use of the word may alone, my lord, it has been held to be, my lord, directory. My lord, this ignores, my lord, the preceding provision, my lord, preceding sentence of the very same provision, as well as, my lord, what follows later, my lord, that within 1 month, if there is no response, my lord, then, my lord, there cannot be, my lord, any, my lord, recovery, my lord, from, my lord, the transferee of past dues. There was no need for it. Second, my lord, is there is no consequence provided. Therefore, my lord, it is not mandatory. The greatest of respect, the consequence is that there is no application. I have no duty to supply you with electricity unless you have given these details. Then, my lord, third, my lord, and my lord, this is my very important. My lord, the object, my lord, of the 2003 Act, my lord, as propounded in paragraph 91 of 9, and my lord, in my lord, the judgment of the learned single judge of the Jharkhand High Court, my lord, has not been taken into consideration at all. And that should have been, my lord, on the basis of which, my lord, 5.3.3, my lord, ought to have been, my lord, construed. Then, my lord, 16.10 Reliance, sorry, my lord, 6.10 Reliance, my lord, could only, my lord, be there, provided, my lord, there was, my lord, a proper application in place. That means, my lord, either a no due certificate or, my lord, an application made and not being done. And then also, my lord, if there is an error in the no due certificate, or, my lord, it is later discovered there are no dues, only two conditions, my lord, under which, my lord, the, my lord, 5.3.3 is diluted, is if it is the applicant itself, or, my lord, a transferee who has a nexus, my lord, with the applicant. But, my lord, 6.10 only comes in if there was a proper application in place. Then, my lord, the next is, my lord, a question of, my lord, waiver. My lord, conduct shows there is no waiver. Number one. Number two, my lord, no pleading on waiver. 3, my lord, if there was a pleading, my lord, of waiver, my lord, I want to have been given an opportunity to file, my lord, an affidavit, and I'm told it was asked for. My lord, the learned judge proceeded on the basis of, it's a question of law. And fourth, my lord, this is important, my lord, waiver, my lord, cannot apply, my lord, to, my lord, statute in any view of the matter. Particularly, my lord, where, my lord, these regulations, my lord, have been made, my lord, in public interest, my lord, to protect public utilities and the consumer. As noted, my lord, in para 91 of 9. And, my lord, if, my lord, 6.10 is to apply, my lord, it, my lord, applies to cases, my lord, where, my lord, a no due certificate is there, but during inspection it is found, my lord, to be defective, not correct. Or, my lord, within 1 month it was not responded to. Then, my lord, if transferee has no connection, you can't recover. It's a fault. You have to bear that, the risk, my lord, of, my lord, that. But, my lord, if it's found that he has nexus, then, my lord, he becomes, my lord, he cannot, my lord, get the benefit of that 1 month, because he is, my lord, actually, my lord, seeking to benefit out of, my lord, concealment. So, my lord, in my respectful submission, my lord, the appeal, my lord, should, my lord, be allowed.
Yes.
Yeah. Well, as I submitted to your lordship at the inception, that, my lord, I am not questioning the power of the legislature to frame regulations for the purpose of in pursuance of the provisions of the Electricity Act. I am not questioning that. So, my lord, the bulk of the submissions which have been made on 9th judgment with regard to, my lord, this promulgation of legislations by way of regulation, my lord, I am not questioning this. What I am submitting before lordship is today that here is a licensee, distribution licensee, who has been approached with an application. The application is this, that I have become a new purchaser of this particular property. Please give me new connection in respect of it. The person who had left the premises, leaving, my lord, the area dues, kindly see that. Will your lordship kindly take, my lord, that page which has been already placed before your lordship by my learned friend. Kindly come to page 166. 173. My learned friend is appearing for a distribution licensee who is supposed to be collecting the dues. Now, kindly note, my lord, page 173, notice given by them. What are the dues? In this regard, the last paragraph. In this regard, Saluja Steel Power is requested to make the following payments, which are outstanding dues. Note this. Of Vishwanath Ferroalloys prior to initiation of the power supply connection process. 8 crores 75 lakhs 93,281 up to April 2010. This is being written in 2022. Your lordships will be entitled to, I am definitely, my lord, your lordship should ask him what he had been doing with regard to these dues. For 12 years, this due have not been collected and nothing has been placed before the court as to what happened to this. The next, 3 crores 39 lakhs 1,344 from May 2010 to August 2012. Again, 12 years to 10 years dues. My lord, my learned friend has very eloquently submitted to your lordship that distribution licenses should be provided with proper finance. If they do not look after their own finance, who can save them? They had been waiting, my lord, for 12 years to, my lord, to find out that if this particular property is purchased by a purchaser, then I shall pursue this claim against them, which is wholly barred by limitation. Kindly, my lord, in this connection, look at, my lord, clause 10.15. I am just starting my submissions on this, page 252. This is one of a Malafides application. Kindly, my lord, see page 252, clause 10.15, recovery of arrears. The Jharkhand rules provide that regulation. No sum due from any consumer on account of default in payment shall be recoverable after the period of 2 years from the date when such sum becomes first due, unless such sum has been shown continuously as recoverable as arrear of charges for electricity supply. My lord, when you cannot get hold of the person who is responsible, liable for this amount of money, you stop my electricity connection on this spacious plea that you should pay a hopelessly barred, time-barred dues. My lord, that is my first submission. My second submission is this, my lord. Kindly come back to page 208 with regard to the interpretation of these clauses. Well, this is a pure question of law. I personally feel that interpretation of these clauses, clause 5.3.3. 5.3.3 of is regarding the purchase of existing property. 5.3 is the conditions for grant of connection. 5.3.3 is purchase of existing property. Where the applicant has purchased an existing property whose electricity connection has been disconnected it shall be the applicant's duty to verify that the previous owner has paid all dues to the distribution licensee and obtained a no dues certificate from him. In case such no dues certificate has not been obtained by the previous owner before change of the ownership of the property, the new owner may approach the distribution licensee for such a certificate. Therefore, my lord, first is the previous owner has to obtain no dues certificate. Previous owner has to obtain a no dues certificate. If he does not obtain that, then, my lord, the new owner may approach the distribution licensee for a certificate. My lord, I ask this question to myself. How do I read this particular? Supposing, my lord, I am a new owner. I have not applied for this no dues certificate. I make an application. I do not apply for no dues certificate. I do not attach a, my lord, no dues certificate with it. Then what is the duty of, my lord, the distribution licensee? He should turn around and say, where is your no dues certificate? Why have you not annexed no dues certificate? I will not accept your application. Did he do this in this particular case? No. They, my lord, went on, my lord, taking money from me for the purpose of feasibility report, for the purpose of survey. Kindly see, my lord, that. Kindly, my lord, come to page 173. My lord, we must look into the activity, the conduct of the distribution licensee. Whether, my lord, they have proceeded in the way my learned friend is suggesting. 174. Kindly come to 174. This is, my lord, on 30th November 2022, one day after they have issued the letter of 29th November 2022 at page 173. And see, my lord, what they are writing. Estimated survey charge in the, my lord, that box. Estimated survey charge to be borne by the applicant, including GST, 15,000. Description of services, support services to electricity transmission and distribution. Accounting code service, number has been given. Then, my lord, the rate of GST, CST, that has been said. And then, my lord, kindly, my lord, take the bottom of that particular, that it has been written to our director. Your application dated 28/9/2022. Dear sir, the feasibility survey for the subject power supply has been completed and the details of which are as follows. Then, my lord, the details have been given. And then, my lord, the amount has been then, clause 8 has been referred to, that disconnected so and so with regard to a separate letter has been issued on 29th November, that has been mentioned. Detailed survey charge, 70,000. My lord, we have paid them this amount of money. They have received this amount of money. Feasibility survey has been done, undertaken by them, and they have looked into it, and they have. Now, my lord, what I am submitting to your lordship, my lord, that proceed on the basis that clause 5.3.3 has not been complied with by me. What they could have done is this. They said, we will not accept your application. I am rejecting your application because it is not completed. They did not do so. They went on with the feasibility survey. They took the money from me. In fact, my lord, they have proceeded step by step. And, my lord, I will respectfully submit to your lordship that if clause 5.3.3 had been a mandatory provision, the first thing they should have done is that I am rejecting your application. This is not an application in the proper form. Now, your lordship may ask me, then what is the purpose of this particular provision? Well, my respectful submission is this, that this particular provision 5.3.3 has been inserted for the purpose of preventing the erstwhile owner, the licensee, who had been taking electricity, so that he may not run away, so that I can chase him out. If he does not give no dues certificate, it becomes an admission on his part that this amount is payable. They will be able to proceed against that particular person, the distribution licensee, for the purpose of recovery of the amount. Now, if they do not do that, if they choose not to, my lord, enforce their own right, well, they will catch hold of a person 12 years after the amount has become due and say that you pay this amount of money, otherwise I shall not give you licensee, contrary to section 43 of the Electricity Supply Act, Electricity Act. Electricity Act section 43 said, if I make an application, you will have to supply. Yes, on the basis of the application which has been made. Now, if you say that application is not complete because one no-due certificate has not been annexed, then, my lord, is it not your duty to, well, I submit to your lordship 5.3.3 is an obligation on the part of the distribution licensee to be aware as to what is happening. Did they know that this fellow, this Vishwanath, has not paid this amount of money? 12 crores of rupees, my lord, 12 crores. It is not 100 or 1,000 or lakh. 12 crores of rupees arrears have been accumulated, and that is sought to be passed on to my client. And 12 crores of rupees, which became due 10 years, 12 years ago. I asked this question to myself, what is the meaning of the last sentence? In case the distribution licensee does not intimate the outstanding dues or issue a no-due certificate within this time, new connection to the premises shall not be denied on grounds of outstanding dues of the previous consumer. Well, the last sentence, well, one cannot ignore this. You can say that, yes, no-due certificate, your obligation to obtain. Supposing I don't obtain, then will you not pursue this matter? And should you not, within 1 month from my application from new connection, say that, look, this no-due certificate has not been obtained. There is not a whisper about no-due certificate anywhere, excepting for my lord issuing that. And my lord, whatever it is, clause 6.10, which is an obligation, again, of the distribution licensee specifically, 6.10, kindly see how it starts. My lord, first of all, kindly see, my lord, the A6 at page 213. Procedure for providing fresh electricity connection. It shall be the duty, kindly note this word, duty of the distribution licensee to issue a duly authorized acknowledgement, application form accepted, inform application. My learned friend says your application form is not complete. If my application is not form is not complete, reject the application. Inform an applicant upon request of the status of the application and reasons, if any, for non-disposal of the application. No such thing is there on record. Then, my lord, kindly come to my learned friend is my lord emphasizing on the word that the application form is not a complete application form. Therefore, this is no application form. Therefore, I am entitled to ignore it. They should have done that, my lord, on that day in 2022. In fact, my lord, what happened was this: in 2019, I have said so, an application was made for connection. Soon after, my lord, the property was obtained. 2019 to 2022, because of the COVID period, nothing progressed, nothing proceeded. Therefore, I kept, my lord, everything, my lord, went into cold storage. And thereafter, in 2022, I revived my application by making that application, which is at page 173. Now, here, your lordship, kindly see clause 6.6 at 214. The distribution licensee shall, at the time of receipt of application form, stipulate a date for inspection of the applicant's premises in mutual consultation with the applicant under written acknowledgement. The distribution licensee shall send its authorized representative to study technical requirements, inspect the premises. This has been done by them on the receipt of my application. And my lord, for that, they have taken the money, I have paid the money. The date of inspection, I am not troubling your lordship. Then, my lord, kindly come to 6.10. Page 215. During the inspection, the distribution licensee shall verify that there is no outstanding due in the applicant's name or for the premises for which new connection is being applied for. If the applicant, my lord, in this particular case, I am proceeding on the basis they wanted to verify, they verified, and they found that outstanding dues are there. Then, my lord, the next sentence. If the applicant, in respect of an earlier agreement, executed in his name or in the name of a firm or a company with which he was associated, either as a partner, director, or managing director, has any area of electricity dues or other dues for the premises where the new connection is applied for, and such dues are payable to the licensee, the requisition for supply may not be entertained by the licensee until the dues are paid in full. I pause here for a moment. Therefore, my lord, here in this sentence, already it's the connection between the new and the old that has been taken note of. Here, my lord, if there is a partner, director, managing director, common in both, etc. In our case, my lord, there is no such allegation, and in actual fact, there is none. These completely two separate entities. So, in a case like this, the distribution licensee is entitled not to entertain the licensee until the dues are paid in full. Then, but if the erstwhile consumer defaulted payment of dues and left the premises, this is exactly in this case, for good, and this is what has happened, and the concerned premises has come in legal possession of a new occupant through transfer, this is in my case, it's a case of transfer, and who has no nexus with the previous owner or occupant in any manner, applies for connection of the electrical line in the same disconnected premises, the distribution licensee shall provide electrical connection without realization of the arrears dues of the premises payable by the erstwhile consumer from the subsequent transferee of the premises, and he shall not be held liable to pay discharge the liability to the previous consumer in securing a fresh connection. My lord, I submit to your lordship, these regulations have been brought into existence in pursuance of section 181 of the Electricity Act. So far as the Jharkhand, my lord, electricity authority is concerned, they were fully conscious of their right, and they were fully conscious as to what they have got to protect, how to protect their own money, how to protect their sources of revenue. But notwithstanding that, they have made this particular provision, which is a provision, my lord, which is, my lord, loud and clear. I don't have any hesitation in interpreting this in any other way. Specifically, it's saying that if any partner, director, or managing director of the erstwhile one has any connection with the new one, then they are entitled to say application may not be entertained. If there is any nexus, the language is the nexus between the two, the owner and the occupant of the new, and, my lord, the old, then, my lord, they are entitled to stop. But if there is no nexus, distribution licensee has been mandated to provide electrical connection without realization of the work. Well, how do I get out of this? I respectfully submit to your lordship, the language of clause 6.10 cannot be watered down, cannot be diluted by I should say, a rather strained interpretation of clause 5.33. Unless 5.3.3 clearly, my lord, dilutes the provision of 6.10, I respectfully submit to your lordship, there is no reason as to why. They should be, my lord, read together. How do I read together? This is both the things are duty of the distribution licensee. No duty of the, my lord, the new entrant. The duty of the distribution licensee, you know what are the dues, outstanding dues. Should you not tell the new licensee, look, this is the due you must pay, otherwise I will not entertain your application. And a due which by their own showing is more than 10 years old, 10 years, 12 years old. And that you are seeking, because you know that if you go to a court of law, you will not be able to realize this amount of money. So how do you realize it? get hold of this particular person. For this 12 crores of rupees, this particular unit will forever remain without a licensee, my lord, a consumer. My lord, nobody will come when they see, my lord, this 12 crores of rupees is due, which is barred by limitation. You cannot claim it more than 2 years old. Well, this the learned trial judge has taken note of. Well, I respectfully submit to your lordship, perhaps the reading, with the greatest of deference to my learned friend, perhaps the reading of the Jharkhand High Court judgment, single bench judgment, is not quite what my learned friend wants it to be. Kindly, my lord, read this judgment. I have not found a proper interpretation of clause 5.3 in this judgment. And clause 6.10 has not been.
আমরা ওই ফর্মে দিই এই ফর্মের রেফারেন্স অ্যানেক্সের টু রেফারেন্স টু ক্লজ 5.5 এ আছে এটা বলছে অ্যাপ্লিকেশন ফর রিলিজ অফ নিউ কলেকশন distribution license of application form so and so in the website for আমরা কিন্তু ওয়েবসাইট থেকে ডাউনলোড করছি so one is that formatted application one is the website application I did not write a letter and ask for supply সেটা 31211
Because if statutory format, page number,
শুরু হচ্ছে 210 এ স্যার হচ্ছে 210
দেখেছি
যেখানে অ্যানেক্সে টু রেফার করেছে বি 5.5
says areas, use of outstanding licensing area. Yes.
application নাম্বারটা রিলিজের এটা 67
second
সেকেন্ড অ্যাপ্লিকেশন
what's happened in that was done so
I don't have any instruction on that but সেকেন্ডটাতে স্যার ওদের নিজেদের নাম্বার দেওয়া আছে this I can also do right so it's generally
So far as this is concerned,
কত পাতা থেকে দুশো কত
শুরু হচ্ছে 200 এটা হচ্ছে যেটা আমরা পুরো 100
will use the charger.
এই বললে করি না এটা ছাড়াও অনলাইনে অ্যাপ্লিকেশন ফর্ম আছে যেটা বেসিসে করেছে নট ইন প্রপার ফর্মাট ইট নট ফাইল
also as left the premises for good. Hmm. He is a chief of a valid concern. There is some company resolution. Hmm.
ওদের ফরম্যাটটা কোথায় কতটা
যেটা ওরা দেখিয়েছে সেটা 170
আমরা যেটা ফাইল করেছি ওদের ফরম্যাটে কি করে যাবে ফরম্যাটে ক্রিয়েট করেছি
সেটা আমি টেক্সট গুলো দেখলে বোঝা যাচ্ছে ওটা সেম ফরম্যাট লেজার পাশাপাশি যদি রেখে দেখি 2 3 4 করে
ঠিক আছে চলো
Yes.
Well, kindly come to my learned junior rightly points out. Kindly come to page 165 of the paper book. 165. This is a letter dated 16th August 2022. Addressed by my client to the Deputy Chief Engineer Commercial DBC. Sir, we have purchased the land of Bishnoth Ferroalloys Limited, Giridi. The name has been given, in which we want to install ferroalloys unit on that land. For that, we need 6 MVA at 33 kV contract demand, and for which we had applied an application in triplicate copy on 26/11/2019, 3 years ago. We are ready to pay the requisite fee of 30,000 through NEFT. All the relevant documents are attached herewith for your kind perusal. So you are requested to complete all the process so that we may get power supply at the earliest. And my lord, the application form, kindly see at page 167. Once it's the second application which we have made, and these were all done, my lord, online. In terms of, your lordship, kindly read this with in connection with this, kindly come to page 210, which has been placed by my learned friend also. Page 210, requisition for new electricity service connection. 5.5 applicant shall apply for release of new connection in the following format as given in the annexure to these regulations. And B is application, A is application form for release of new connection, application for release of new connection high tension. We are in B. And then my lord, kindly turn over the page. 5.5.2. The application form shall be available at the local office of the distribution licensee free of cost. The distribution licensee shall also put up a copy of all application forms, agreement formats, existing tariff schedule and schedule electricity supply code on its website for free download. Legible photocopies of the blank form may be made. And my lord, kindly, if your lordship compares, my lord, the application form, which is, my lord, is at page, which my lord friend has shown to your lordship, page 271. And my lord, it is almost the same as what is, my lord, annexed there. Of course, my lord, the no dues certificate is not annexed. I can concede that. But nobody insisted on no dues certificate. They should have insisted. No dues certificate, my lord.
The application given by the writ petitioner is not in the form in annexure 2.
Yes.
Online agenda ছিল
My lord, whatever, my lord, we
That was
obtained, my lord,
processed.
we made the
They
application
processed
in
that.
that, in that form. My lord, the point is that if this was not in form, then what should have been done? You should have pointed out that it is not in form. You download the form, actual form, from our website, and then you fill it up. They did not do so. They accepted our form. They, my lord, proceeded on the basis, and my lord, they issued the notices
173 and 174.
and 173 and 174, my lord, which I have.
The same application form.
And my lord, they have referred to the same application form, and they have not said that this is not in order. But be that as it may, what I am submitting before lordship is this: 6.10 is, my lord, has not been considered, my lord. It does not appear to have been considered by, my lord, the Jharkhand High Court in the single bench. And so far as the division bench is concerned, your lordship will be pleased to come to page 18 of that. By this, my lord, the order of the trial court was set aside. Therefore, my lord, in my respectful submission, this will have no value as a precedent. But be that as it may, kindly come to page 17, the last paragraph. Para 21. It has been rightly held by the learned single judge that clause 5.3.3 did not have a retrospective effect. Absolutely correct. As such, the purchaser of a property prior to coming into force of Electricity Supply Code regulation from 7/9/2015 would not be denied fresh electricity connection on the ground that he had not been able to obtain no dues certificate from the previous owner before changing ownership of the property. However, and this is the most important part, however, fresh connections could be denied if such a purchaser had any nexus with the previous owner, occupier, in any manner, or he was associated either as a partner, director, or managing director, what I have submitted to your lordship, in respect of the earlier agreement executed in his name, or in the name of a firm or a company, considered thus refusal of electricity connection to the appellant relying upon clause 5.3.3 of Electricity Supply Code regulation is unsustainable in law and on facts. I read this, my lord, that this is really reading clause 6.1.0, 6.10, and, my lord, clause 5.3.3 together. Accordingly, the impugned judgment dated so and so, declining to interfere with the order of 31st May 2017, refusing fresh electricity connection in favor of the petitioner appellant, is set aside. Consequently, the order dated 31/5/2017, impugning the petition, refusing fresh electricity connection in favor of the petitioner, stands squashed. What remains of the trial court judgment? And that cannot be cited as a precedent in any event. And, my lord, this is the judgment which had taken note of 6.10. This is a Jharkhand regulation. They themselves have provided this. I agree with my learned friend that, my lord, the legislature is entitled to frame regulations for the purpose of governing the relationship between the distribution licensee and consumer. But I say that read these particular provisions carefully. These provisions, my lord, if read carefully, my lord, in my respectful submission, one cannot escape this conclusion that there is a provision that without establishing a connection between the erstwhile owner and the new consumer, new applicant, my lord, the liability of the erstwhile owner cannot be foisted upon the new. Well, this is exactly what the learned trial judge has held in the facts of this particular case. Well, we have got judgments before you. If your lordship, my lord, looks into just one or two judgment, their decisions of the Supreme Court, আমাকে 2026 Supreme Court case দিল। When 2020 volume 6 Supreme Court cases, page 404.
So that was still plan. It's single because of the expression.
Well, these are all auction purchase. Sorry.
Determine these.
Yes.
My lord, kindly come to my lord. Page, this is my lord, 2026 Supreme Court cases, page 404. A division bench judgment of the Supreme Court. My lord, kindly come to paragraph 4 once. The aforesaid auction notice shows that the unit was being sold on as is, where is, what is there, what there is, and without any recourse basis, as per rules 8 and 9 of the security interest rules. The aforesaid clauses of the e-auction sale notice show that the total outstanding dues were much larger, but the reserve price fixed was lower, and the actual sale consideration of the successful auctioneer was rupees 9 crores 18 lakhs, which is approximately rupees 10 lakhs more than the minimum reserve price. Clause 24 reproduced aforesaid makes it clear that when the reference is to a sale on as is, where is, what is there is, and without any recourse basis, the same is in all respects subject to the statutory dues. This clause was further subject to another clause 26, where the authorized officer carrying out the auction absolved himself of the liability for any charge, lien, encumbrance, property tax, dues, electricity dues. The purpose is to emphasize that a holistic reading of all these clauses left little doubt that the auction notice provided for a reserve price with a bidding being made about rupees 10 lakhs over and above that, and certain nature of charges, lien, encumbrances, including electricity dues, were clearly beyond the sale consideration paid. We may next turn to sale deed dated so and so, executed in pursuance of the auction, which provided for the sale made free from all encumbrances known to the secured creditor. Now, my lord, I just would request your lordship to read one clause, this same similar clause in all 4 deeds of conveyance. My lord, one clause here at page, kindly, my lord, take, this is a part of the deed of conveyance in my client's favor, page 61. Page 61, and this has been taken note of by the learned trial judge also. Clause 5. That the cash possession right, marketable title which the executant has in the aforesaid lands are free from all defects and encumbrance. If any defect is found for which, if the vendee suffers any loss damage, then the executant shall be responsible and legally bound to pay the same. Specific clause is there. My lord, all these auction matters which were before the Supreme Court, they are the specific clauses as is, where is basis. So you buy keeping your eyes open. You know exactly what you are buying. If there are encumbrances, then you buy along with the encumbrances. Because as the Isha Marbles 1995 Supreme Court said that electricity charges do not form charge on the property, but it can be made a charge on the property by specific provisions in the statute. And here, my lord, if it says that if the person concerned who is buying it, he buys it with the encumbrances, then my lord, he is liable to pay the taxes also. I mean, the charges for electricity also. So, my lord, keeping that in mind, if your lordship, my lord, looks into this particular judgment, and my lord, because of the nature of the clause, paragraph 5, kindly see the last sentence. An indemnity was provided by the vendor to the respondent against any loss arising out of any defect in the title, including recovery of statutory liabilities, taxes, as also litigation expenses out of such defects in title. This indemnity was thus confined to aspects mentioned in the clause, but relatable to defects in title and not to other liabilities like the electricity dues.
Sir, we'll continue in the second half.
Yes, well, I shall not take more than 15 minutes.
We'll come back at 2:15.
Lordship. তুমি সমস্ত প্রত্যেকটা জায়গায় চেক করো My lord, in this particular judgment, I shall just place only one paragraph. I don't want to unnecessarily encumber your lordship's record by citing judgments after judgment. Kindly come to para 13. Quoting my lord from this is my lord, I was citing before lordship 2026 Supreme Court cases.
Yes, Telangana State South Power.
Yes, the same view in the similar para 12. We may also notice that an auction purchaser bidding in an auction and as is where is whatever there is and without recourse basis, the respondent would have inspected the premises and made inquiries about the dues in all respects. The facts of the present case, as in the judgment aforesaid, are more explicit in character, as there is specific mention of the quantification of dues of various accounts, including electricity dues. The respondent was thus clearly put to notice in this behalf. The same view has been same view in the case of a similar clause has been taken in Pashchimanchal. It has been further observed that if any statutory rules govern the conditions relating to a sanction of a connection or supply of electricity, the distributor can insist upon fulfillment of the requirement of such rules and regulations so long as such rules and regulations or the terms and conditions are not arbitrary and unreasonable. A condition for clearance of dues cannot per se be termed an unreasonable or arbitrary. Well, we have got nothing to say with regard to this. Well, the only other judgment I would like to cite before Lordship is 2013. 2012. 13 Supreme Court cases, page 479. আমার copy দিচ্ছি আছে copy দাও Well, paragraph 6, your lordship kindly says. The only point for consideration in this appeal is whether a company which purchased the property of another company under liquidation through auction is liable to pay the arrears of electricity dues outstanding against the erstwhile company. Well, each of these cases I find is on auction. Well, kindly come to. Well, in this judgment, a distinction has been made between transfer of service connection, that means a continuing process, and my lord, giving a new connection. In this case, my lord, I am not troubling your lordship with that portion. Kindly come to your lordship will kindly come to paragraph 17. Well, all these cases are relying upon earlier decision. So that has been quoted. Kindly come to paragraph 16. Pashchimanchal. I am not troubling your lordship independently with these cases. These are all quoted here. In Pashchimanchal Vidyut, the question whether the supplier can recover electricity dues from the purchaser of a subdivided plot was considered by this court. The following conclusion is relevant. The supply of electricity by a distributor to a consumer is sale of goods. The distributor as the supplier and the owner or occupier of a premises with whom he enters into contract for supply of electricity are the parties to the contract. A transferee of the premises or a subsequent occupant of a premises with whom the supplier has no privity of contract cannot obviously be asked to pay the dues of his predecessor in title or possession, as the amount payable towards supply of electricity does not constitute charge on the premises. A purchaser of premises cannot be foisted with the electricity dues of any previous occupant merely because he happens to be the current owner of the premises. The supplier can therefore neither file a suit nor initiate revenue recovery proceedings against the purchaser of a premises for the outstanding electricity dues of the vendor of the premises in the absence of any contract to the contrary. Then, my lord, Pashchimanchal Vidyut case, para 12 has been quoted. But the above legal position is not of any practical help to a purchaser of premises. When the purchaser of premises approaches the distributor seeking a fresh electricity connection to its premises for supply of electricity, the distributor can stipulate the terms subject to which it would supply electricity. It can stipulate as one of the conditions for supply that the area dues in regard to the supply of electricity made to the premises when it was in occupation of the previous occupant should be cleared before the electricity supply is restored to the premises or a fresh connection is provided to the premises. If any statutory rules govern the conditions relating to sanction of a connection or supply of electricity, the distributor can insist upon fulfillment of the requirement of such rules and regulations. If the rules are silent, it can stipulate such terms and conditions as it deems fit and proper to regulate its transaction and dealings. So long as such rules and regulations or the terms and conditions are not arbitrary and unreasonable, courts will not interfere with this. If we apply the above principles as pointed out by Mr. Tripathi, learned counsel for the appellant, undoubtedly respondent number 1, purchaser of the premises is liable to pay entire arrears of outstanding power dues. However, as pointed out by Mr. P.P. Rao, learned senior counsel, respondent number 1, is not a party to the contract with the supplier, that is NESCO. We have already quoted the relevant clauses, particularly clause 10b of regulation 13, which is not applicable to respondent number 1 hearing. In other words, as mentioned in the earlier paras, in the case on hand, respondent number 1 has not applied for transfer of service connection from the name of the erstwhile company to its name, but applied for a fresh connection, as in our case, my lord, fresh connection to it until the purchasing to its unit after purchasing the same from the official liquidator. Then again, my lord, the same thing has been reiterated in Ahmedabad Electricity, the next paragraph. We are clearly of the opinion that in case of a fresh connection, though the premises are the same, the auction purchaser cannot be held liable to clear the arrears incurred by the previous owners in respect of the power supply to the premises in the absence of there being a specific statutory provision in that regard. In the recent decision of Haryana SEB, that position has been summarized. It says this, para 12, electricity areas do not constitute a charge over the property. Therefore, in general law, a transferee of a premises cannot be made liable for the dues of the previous owner's occupier. Where the statutory rules or terms and conditions of supply, which are statutory in character, authorize the supplier or electricity to demand from the purchaser of a property claiming reconnection or fresh connection of electricity, the area dues of the previous owner occupier in regard to supply of electricity to such premises, the supplier can recover the arrears of the purchase. My lord, what I'm emphasizing is this. I do not find in these provisions, including clause 5.3.3, there is a specific obligation of the newcomer
Yes,
that he will have to clear the dues. Well, if your lordship looks into the clause 5.3.3 again, it is the other way around. It says that in case the distribution licensee does not intimate the outstanding dues or issue a no dues certificate within this time, new connection to the premises shall not be denied on the ground. So, my lord, the onus has been shifted upon the distribution licensee both under 5.3.3 as also under 6.10. 6.10, same thing. That only in case, my lord, where can, my lord, if I may respectfully submit this way, these provisions have circumscribed the area within which, my lord, the distribution licensee can move. Distribution licensee can claim the area dues if there is a nexus, if there is a connection. And that is the right which is mandated by these rules. So, my lord, unless the connection is established, you cannot claim. Unless your lordship, my lord, looks at it from that point of view, I will respectfully submit the interpretation given by my learned friend on the other side of clause 5.3.3 will render nugatory the provision of clause 6.10. Clause 6.10 in its pristine glory is standing by itself. If you want to claim, establish nexus. If you cannot establish nexus, you cannot. Specific provision. Nexus. And my lord, it is an admitted position that there is no nexus between these two. No such allegation has been made, no such submission has been made, and my lord, it cannot be made because factually it is not possible to make. So, my lord, I rest my case on this, that if your lordship looks into the application, my lord, no defect in the application has been pointed out. So, my lord, the respondent at no point of time has said that you take back your application. This application is not complete. If they had said so, I would have made a fresh application. No problem. Tomorrow I shall make a fresh application because the property is mine. I have spent crores of rupees for the purpose of purchasing this property to set up this industry. Today, if you say that this is not in term, tomorrow I shall come up with an application. They never said so. I never went. For 3 years, my application was pending, 2019 to 2022. And then again, 2022, I renewed my application. There also, they did not say your application is not proper.
Accepted money and
On the contrary, my lord, on the basis of this application, they have accepted
proceeded.
money and they have proceeded with this. My lord, these are my respectful submissions.
My lord, may I take, my lord, 5 minutes, my lord?
Yes, sir.
My lord, a point, my lord, was argued, my lord, relying on, my lord, I'll just go, my lord, stereotype, my lord, as to what was, my lord, submitted. My lord, the first point, my lord, which was argued, my lord, was, my lord, reliance on, my lord, clause 10.15. And my lord,
Limitation.
yes, my lord, your lordship, my lord, was shown that clause. And my lord, on that basis, my lord, and my lord, the letter, my lord, that it was, my lord, used for, my lord, 12 years, my lord, and therefore, my lord, it's barred by limitation. My lord, this is actually, my lord, a reproduction of section 56(2). My lord, of, my lord, the Electricity Act. My lord, kindly see, my lord, it's read, notwithstanding anything contained in any other law for the time, no sum shall be recoverable after a period of 2 years from the date when such sum became first due, unless such sum has been shown continuously as recoverable as arrears of charges from it, and the licensee shall not cut off the supply of the electricity. My lord, this provision, my lord, which is akin, my lord, I mean, really, my lord, 10.15 takes it from there. My lord, is, my lord, a provision for, my lord, disconnection. My lord, that is, my lord, what, my lord, the Supreme Court, my lord, I'm not, my lord, citing a new case. I'm, my lord, just giving your lordships, my lord, the reference 2020 4 SCC 650. Secondly, my lord, the point of limitation cannot arise till such time as the tariff determination is made, my lord, finally. The final tariff determination for this period, my lord, was made in October 2023. I have the tariff order. Because that, my lord, is the starting point for limitation. My lord, I'm not on anything else. Previously, my lord, whatever is being billed as per tariffs, my lord, charged by DVC. But, my lord, the entire thing, my lord, is subject to, my lord, the result of, my lord, the tariff commission, my lord, deciding this. And, my lord, this is also the, my lord, being so held by our High Court. My lord, that starting point for limitation, my lord, has to be, my lord, the determination of final tariff, and, my lord, bill, my lord, raise, my lord, on that basis. Because, my lord, the actual amount due is only determined, my lord, after the tariff is finally determined. And your lordship seen, my lord, the Supreme Court in this very judgment, your lordships will find, even after 2 years have gone by, my lord, I can, my lord, again raise a bill and, my lord, say this you have to pay. Specifically, my lord, the Supreme Court comment construing, my lord, 56(2). And the learned judge, my lord, though this was relied on, my lord, did not decide on that basis. My lord, your lordships will find that, my lord, in, my lord, the impugned order, my lord, paragraph, my lord, 57. Kindly take, my lord, page 15 of the impugned order from the memorandum of appeal. Hence, even without going into the bar of section 56, read with clause so and so by the absence of any nexus being proved so and so.
But 10.15
Yes,
says that no sum due from any consumer.
yes.
Con-
Unless it's current, shown, my lord, it continues to
But
be.
consumer is defined under clause yes to mean a person who is supplied with electricity for his own use.
Correct.
But he is yet to be supplied with electricity. The electricity connection was disconnected
2012.
12 years
Yes,
back.
at 2019, he transferred.
He has purchased the immovable property.
Correct.
And the sale deed does not contain any
No.
conveyance of the service rights over the service connection, because once you have disconnected, you will forfeit the security deposit. Beyond a period, you will dismantle the entire connection. So therefore, unless this limitation clause was on the consumer, that is the consumer is the Biswanath.
Yes.
So if you could not have recovered it from Biswanath within this time, assuming within this 2 years, can you do it?
My lord, I can recover it. Let me cite the Supreme Court because this was not decided by the learned judge. My lord, two facts have to be proved here. My lord, number one, my lord, is, my lord, that there was, my lord, a sum which was due and which was not being shown to be due. Kindly read, my lord, clause 10.15.
Yes, it has to be, because in a running bill,
yes,
if he is a high tension consumer, not in every default they will disconnect.
Correct.
Because he is a priority sector.
Correct.
So domestic supply, 1 month you default, they'll disconnect. Low tension. So what they'll do in a running bill, you keep on showing that.
Correct.
You will add e-tax, you will have penalty,
Correct.
you will add surcharge.
Yes.
Then you will record the present consumption.
Correct.
So he will keep on servicing the present consumption, keep that hanging.
Correct.
Then write to you saying, sir, please give me installment that this.
So that's a question of fact.
But here, such a running bill was never.
My lord, I haven't filed an affidavit. I was asked to file, not given. My lord is saying it's decided on a question of law. That's why the learned judge doesn't even go into this. But I'll show your lordships, my lord, the judgments. Now, my lord, what is important is, my lord, kindly have a look. My lord, may I, my lord?
Then we will restrict it to nexus, that is 5.3.3 and 6.1.
Yes, because I could have, my lord, cited this, which says, my lord, the limitation period, my lord, can be revived any future time also, my lord, when
Against the consumer.
Correct. And
He
my
is
lord,
not the consumer as of now.
my lord, it's yes, but it's the dues of that consumer, my lord, which has to be paid.
That has to be considered.
Yes.
Whether
Yes.
what is the interpretation?
Yes, my lord, the dues of that consumer has to be paid. I'm not saying, my lord, that, my lord, he is the consumer today. I'm saying the dues of that consumer has to be paid. And the learned judge didn't go into that because, my lord, it's a question, it's a mixed question of fact and law. Learned judge decided not to go into it. I can, my lord, go into it before your lordships. I have no problem. Because, my lord, I am covered by Supreme Court and a judgment of this High Court saying limitation doesn't apply. My lord, till such time as tariff is finally determined. The starting point of 56(2) does not arise. My lord, this is, my lord, what I wanted to submit, my lord. But, my lord, most importantly, my lord, kindly take, my lord, paragraph, my lord, 7 and 10 of the writ petition. I'll show it from here. My lord, kindly come to, my lord, all this case of waiver, you've not done anything with the application, etc., etc. My lord, I want to make one thing very clear. My lord, they applied in 2019. My learned friend has shown, my lord. Now I want to tell your lordships, my lord, their case in the petition. After this, my lord, the arguments that have been made, my lord, cannot, my lord, arise at all. They could not have been made. Kindly take, my lord, page 28, my lord, of the stay petition. I'll just read 4 paragraphs. My lord, by a letter dated 26 November 2019, the petitioner number 1 informed the chief engineer commercial of respondent number 1 that petitioner number 1 was setting up a ferroalloys unit at the property for which the petitioner number 1 was in need of power with contract demand of so-and-so. Petitioner number 1 furnished the application for new connection in prescribed form and with 3 copies as required by DVC. Along with the application form, petitioner number 1 had also furnished its registration certificate, memorandum and articles of association, copy of the legible Mosa map and copy of sale deed executed in favor of so-and-so. Copies of the letter dated 26 November 2019 with the enclosures thereto are annexed here too and collectively marked as annexure P5. My lord, that your lordships will find. My lord, at Moja map ta to onek aage hai. Before the conveyance date. My lord, page, my lord, 109, my lord, page 109. Lordships, my lord, will find that. This is, my lord, their application. Which they, then, my lord, the respondent number 1, my lord, my lord, nothing stated here about, my lord, past dues, my lord, no due certificate, nothing. Respondent number 1, despite receipt of the letter dated 26 November 2, issued by petitioner number 1, enclosing copies and other relevant documents, did not take any step for a new connection to be allotted in favor of petitioner number 1. The officers and representatives of the petitioner number 1 established contact with the office of respondent more than one occasion after November to ascertain progress of request. However, on and from second week of March 2020, entire country faced with a crisis situation caused as a result whereof app did not receive desired attention. It is in such circumstances and only after things improved since middle of 2022 that the petitioner issued a letter dated 16th August 2022 requesting to complete the process pending. The petitioner informed this is the letter which was placed 16th August. Now, my lord, despite receipt of the letter dated 16th August, petitioner number 1 was not provided with a new connection for supply. In order to ascertain the reason for not taking steps and or acting in terms of the request of petitioner number 1, petitioner number 1 deputed its officers, namely Shashi Kumar Sinha, to visit the office of respondent. Accordingly, sometime in the middle of September 2022, the said office of petitioner number 1 visited the office of respondent number 1 and inquired from the respondent number 2 as to reason for withholding and are not taking any action on for new connection. And in course of such inquiry, respondent number 2 informed officers that there were past dues of Vishwanath ferroalloys which were required to be cleared and paid before any progress could be made. So this is, my lord, happening, my lord, on their first application. When they go, then, my lord, your petitioners state that your petitioners were shocked and surprised to note respondent number 1 and its officers were insisting upon dues of payment of prior consumer from the petitioner number 1 before taking any steps filed by petitioner number 1. Officers of petitioner number 1 confronted to and sought for justification and explanation as to why petitioner's application for new connection was not being considered further, why wrongly imposed as a liability on petitioner. However, despite much effort, petitioners could not convince the respondent authorities an application for new connection ought to have been considered and allowed without demanding past dues of so-and-so. So there was, my lord, they said, sorry, we are not going to process it further because there is no valid application. You are liable to pay. Now what do? Your petitioners state that petitioner's first application on so-and-so remained pending for more than 3 years. Upon being advised by respondent number 1, petitioner number 1 filed another application for a new high tension pass connection from respondent. Along with the said application, petitioner number 1 remitted by way of bank transfer a sum of ₹35 towards application fee to respondent. The application for new connection was made online as required by respondent number 1. Copy of application made by so-and-so with other relevant documents. Now, my lord, what is important is we are still at the first stage because now kindly have a look at our letters. My lord, payment has been made. My lord, there is a difference between application and an application form. Kindly come, my lord, back to the regulations, my lord, which I want to show your lordships. 95, so 195. My lord, page 195. My lord, kindly take, my lord, page 195. My lord, kindly see what, my lord, kindly see definition 2.3 F. My lord, at page 199. Application form means an application form complete in all respects in the appropriate format as required by distribution licensee. Kindly mark the next. Before any payment of applicable charges. Now kindly come to application. Application means an application form complete in all respects in the appropriate format as required by the distribution licensee. So that's application form, along with document showing payment of necessary charges and other compliance. So, my lord, when I take the charges, my lord, that is something which has to come, my lord, with the application form. Now, what do we write to them? My lord, kindly have a look at the letter. My lord, at page, my lord, 173.
Yes.
Kindly see, my lord. 29 November. Regarding connection, this refers to your application, etc. Now kindly see, my lord, the portion which was placed. In this regard, Saluja is requested to make following payments which are outstanding dues so and so prior to initiation of the power supply connection process.
That's what I'm telling.
And that is, my lord, we are back at, my lord, 5.3.3 stage because we are pointing this out. Delayed will be applicable as per prevailing so and so. We are, my lord, at the first stage. I'm saying I've collected. Now you making all these payments, fine. Now you please, this is another payment which you have to make. My lord, kindly see page 152. Sorry, my lord, 174.
Some more documents. Some more documents may be.
Correct. And not just that, my lord, it, my lord, shows clause 8 at page 176.
176.
My lord, the premises on which new has been applied for belong to so-and-so is disconnected to clear outstanding dues. For which a separate letter, my lord, that's the letter which was sent to them. My lord, all through, my lord, we've been insisting on this. The first stage, even the 2019 application was not processed, which was checked verbally, told that you have to do this. Then they filed something online, they're again told these are the charges because the application, not the form. First form, my lord, is as per prescribed, my lord, by the distribution licensee. The second form, my lord, which I showed your lordship, my lord, is, my lord, has to have 22, 23, 24 along with the documents. That's part of the regulation. So, my lord, today, even today, my lord, we do not have a completed application. And section 43, my lord, says the explanation, it has to be a completed application.
Learned friend should not re-argue the points. I mean, all.
No, I'm not re-arguing. My learned friend relied on all this.
You're re-arguing the entire thing.
Because my learned friend didn't point out, my lord, the difference between application and application form.
No.
It's been equated.
I think my learned friend had not got my point. I said
no,
that application or no application, you have no right to deny me the electricity connection. Why? Because of 6.10.
And my lord, my
6.10, if I do not comply with, then you can say that I will not give you electricity. But so long as 6.10 is there, you will have to give me connection.
My lord, and I will give my learned friend credit for, my lord, understanding my argument and not dealing with it. That when I say when 6.10 comes into play and when 5.33 come into play. My learned friend, my lord, unlike my lord, the credit he's given me that I didn't follow my learned friend's argument. My lord, he followed my argument, my lord, but did not, my lord, deal with it.
I did.
My lord, which was,
I
my lord, that they are at two different stages, which the learned judge also did not consider. And my lord, 6.10, my lord, is, my lord, if, my lord, the dues, my lord, there's an error in the overdue certificate, because this has to be done before, my lord, the person purchases. At the time of purchase. So, my lord, if there is an overdue, no due certificate, then, my lord, I can't blame him if he has it, or he's asked for it and I've not given it, unless, my lord, there is a nexus or the applicant himself is, my lord, in.
Who's to prove the nexus? Or who's to?
My lord, if it's only 6.10, which is applicable, I have to prove the nexus. My lord, I'm not, my lord, joining issue there.
Because 5.3.3 does not provide for a recovery mechanism.
Right?
It doesn't provide
No,
for a recovery
no, but
mechanism.
it doesn't allow the application to proceed.
Doesn't say that you cannot.
Application cannot proceed.
Say so. But
It's a condition for grant of electricity.
Because it's a condition, my lord, for grant of electricity.
No, there are 2 or 3 limbs to 5.3.
Correct.
The first is the onus is on the applicant who purchased the property whose electricity connection was disconnected. So that was the writ petition. First limb of 5.3.3.
It's his duty to verify.
It shall be the duty to verify.
Yes.
That the previous owner has paid all the dues up to the distribution, obtained no due certificate from him. According to them, in one of the covenants in the sale deed says, no more money is payable.
No, nothing. My lord, what was shown to your lordship has nothing to do with electricity charges.
No, nothing to do. What it says is there is nothing more to be paid to the vendor. He's the vendee. That's the condition. It doesn't say about electricity.
No, nothing. It cannot, my lord, because electricity charges do not constitute a charge.
So let us assume he, as the purchaser of the property, verified. Found that there was no electricity connection in the premises. Consequently, no bills were raised. Probably. So, therefore, he might have formed an opinion that a no due certificate is not received. In the event, it says, in case such no due certificate has not been obtained by the previous owner, the new owner may approach. That is why the learned single bench says the expression may is directory, not mandatory. I may approach as a purchaser.
Or I may not.
I may not approach.
Very well.
If I approach, you don't pass orders within 30 days, you cannot demand. Let us take a case where he has not approached. Then, if you have to get hold him responsible in terms of 6.10.
No, I'm not even going there. My lord, that is the second limb. My lord, I am saying there is no application because he is not indicated, my lord, in his application, whether there are dues or not. He has to disclose that. I am not required to proceed at all. And it's not something that he didn't know.
He knew.
He knew. His own pleadings, my lord, say that. He knew that. And my lord, kindly see, my lord, and my lord, my lord, with the greatest of respect, my lord, to the learned judge, my lord, taking, my lord, one sentence and saying, my lord, from a clause, my lord, that it is, my lord, directory and not mandatory, is, my lord, with the greatest of respect, my lord, not the right test. My lord, one has to keep in mind, my lord, the purpose, my lord, of the act, my lord, the purpose of the regulation, and, my lord, the duty cast shall verify that has paid all dues and obtained. It's not just verification, and obtained a no due certificate. He has not, my lord, exercised that duty. Yes, there's nothing there, no bills raised. So should have asked the owner, where's the new due certificate? It's not his case that he asked and he said no. So he knew, my lord, that there were no due certificate. No due certificate. Because, my lord, if, my lord, the third sentence has to be given, my lord, any, my lord, force, my lord, there was no requirement that you cannot refuse. Kindly have a look, my lord, at the, my lord, the third distribution shall acknowledge receipt of such request, shall intimate in writing the dues outstanding, if any, or issue a no due certificate within 1 month from date. In case that it does not intimate the outstanding dues or issue a no due certificate within this time, new connection shall not be denied on grounds of outstanding dues. In such an event, distribution line have to recover his dues from. Would make no, I'm sorry. There was no requirement, my lord, with the greatest of respect, the third sentence. If we didn't.
Yes, sir.
Now, my lord, the two cases, my lord, which have, my lord, been relied on, my lord, 2026 SCC 404 and my lord, 2012 SCC online SC 930, my lord.
Has been considered.
My lord, Telangana, my lord, has been considered in Ninan's judgment, my lord, which I cited. My lord, in fact, my lord, I would say, my lord, that this really, my lord, helps me. My lord, because, my lord, if there are restrictions, the question is whether there's a restriction or not under 5.3. That is, my lord, the real, whether, my lord, that needs to be complied with before, my lord, one can have an application. Because the right, my lord, is not absolute under section 43. That, my lord, Ninan, my lord, has discussed, made it very clear. And it's also said what is the object. My lord, that, my lord,
was not available when the judgment was, when the writ petition was heard.
I don't know if it was, my lord, there, my lord, when the writ petition was filed, but
No.
Ninan was not cited. My lord, my lord, before your lordships, my lord, I thought I'd cited, my lord, which
So, Ninan was decided on May 19th, 2023.
Yes, ma'am.
This judgment was in March, I think.
Correct. So it wasn't available.
9 judgment was not there.
It was not there.
This is the judgment has been delivered on 24th March. 24th March.
19th May 2020.
Maybe 9 judgment doesn't have advance the case.
My lord, in fact, my lord, 9. And my lord, this is considered, my lord. My lord, Telangana, my lord. And my lord, it really assists me. And my lord, this, my lord, Raghunath Paper Mills. My lord, again recognizes, my lord, the position, my lord, in Paschimantral Vidyut case, my lord, which is, my lord, also considered in 9. And my lord, that there can be provisions made, my lord, apropos this. My lord, which my learned friend, my lord, has considered. So it really, my lord,
Provisions can be.
my lord, doesn't, my lord. Yes. Now my learned friend, only one other submission my learned friend made, that there was something more than retrospectivity, my lord, in, my lord, the division bench judgment of, my lord, the Jharkhand High Court. My lord, I believe, my lord, my learned friend, my lord, is probably not correct here. My lord, kindly take, my lord, the last paragraph, my lord, which my learned friend read, my lord, on this behalf, and said 6.10 was considered. My lord, the same provision was there in the earlier code. Kindly have a look, my lord, because it said, my lord, that 5.3.3 will not apply because before 2015 the transfer had taken place. So by same logic, 6.10 could not have applied. But my lord, why did they apply, my lord, what they said in para 21? I want to show your lordships that. Kindly take, my lord, the Jharkhand division bench judgment, para 21, my learned friend read. It has been rightly held by the learned single judge that 5 points did not have retrospective effect as such. But my lord, what did the court hold? Look, you're making the application after 2015. So though it doesn't have retrospective effect, though transfer has happened earlier, but you're making the application now, so retrospective effect will not come in. My lord, that's what it was. Now, my lord, kindly see, could not be, as such, purchase of a property prior to coming into force of so-and-so could not be denied on the ground that he had failed to obtain so-and-so. However, fresh connection could be denied if such a person had any nexus with the previous owner or occupant in any manner, as he was, or he was associated either as a partner, director, so-and-so firm. Considered thus, refusal of electricity relying on so-and-so is unsustainable in law and on facts. Now, my lord, my learned friend said this is 6.10. Kindly have a look at, my lord, the earlier part of the order. My lord, page 8, my lord, of, my lord, the, kindly have a look, my lord, paragraph 8, why the court wanted this matter to go back and be considered in the light of, my lord, clause 5.5 of Electricity Supply Code Regulation 2005. Now, my lord, kindly read this, my lord. I have, my lord, para 8. I have considered submissions canvas so-and-so 2005, and I have also perused and gone through documents. In order to appreciate the controversy in light, reproduce 5.5. Kindly see 5.5. If the applicant, in respect of an earlier agreement executed in his name or in the name in which he was associated either as a partner, director, or managing director, has any arrears of electricity dues or other dues for premises where the new connection is applied for and such dues are payable to the licensee, the requisition for supply may not be entertained by the licensee until the dues are paid in full. Then, my lord, but if the old consumer who had committed default has left the premises for good and the concerned premises has come in legal possession of a new occupant through transfer or purchase of concerned property, and where the new incumbent is not connected with the previous owner occupant in any manner, applies for reconnection of the electrical line in the same, in that event, the dish shall be obliged to order. That was the, my lord, test, except, my lord, there was no 5.3.3, my lord, in the 2005. That has come in now. And one more change has been made to what 5.5 was. It is also transfer by or possession by reason of a decree of order, decree of court. But, my lord, if there is a nexus, if it's connection, my lord, that is, my lord, what 6.10 has and also 5.5, which is why para 21, doesn't refer to 6.10. Then you go back and have it examined on this.
That is why they sent it for a fresh
Correct,
decision.
correct.
in
Because,
accordance-
my lord, on 5.3.3, it didn't apply, so we don't need to go into it.
But 5.5, you'll have to consider.
Yes. And that had, my lord, which is why, my lord, there has to be a meaning, my lord, to, my lord, 5.3.3 coming in. My lord, if it was only restricted, now, my lord, this is the Jharkhand code. My lord, the tariff commission, my lord, had, my lord, 5.5 earlier, which is 6.10. My lord, there has to be a purpose for 5.3.3. And my lord, this amendment to, my lord, 2005, my lord, 5.5 was introduced in 2007. My lord, I have the, but at the relevant time, my lord, it was what was there. My lord, there is no valid application.
That is not the case at any point of
Which is why
grounds at 835. He says, officers cannot demand payment of dues prior consumer before taking any steps on the application, file the petition or something.
The first petition.
Yes.
Those are my submissions.
Well, I just wanted to add two sentences to your submissions made. First submission is this, my lord, that my learned friend says that I did not argue the point of no application. I avoided. I didn't. Perhaps my learned friend did not pay attention to my submissions. I said that, my lord, at page 174, if I had no application, did my lord kind come to page 174? Their own. I placed this before your lordship. The last part of it. The first part, Damodar Valley Corporation is writing this. They are saying how much money is to be paid, etc. Then, my lord, the feasibility survey for the subject power supply has been completed, and the details of which are as follows. And what is this? Your application, reference your application dated 28/9/2022. So my application has been treated as a proper application. Thereafter, my lord, they have been asked me for a feasibility survey. And my lord, on the basis of this, I have paid this 17,700 rupees, which is at page 176 for feasibility survey. They have made the survey. In fact, I was going to make this submission to your lordship that when your lordship is considering this judgment, but allow me to proceed with this, I shall take the risk. My lord, in the meantime, the power supply will not be affected. But in the meantime, let me complete all these things. I have already proceeded to complete this. And my lord, they have allowed me to complete this. And now today they are saying no application. That is my...
After this communication, what have you done?
After this, my lord, I shall show your lordship a flow chart, what I have done. This, of course, is not there on record, but since your lordship is asking me, I shall just tell your lordship. My lord, detailed survey was done. Detailed survey report was given. Then, my lord, service charge and applicable tax, that was done. That was paid. And construction clearance has not been done.
This is awaited.
This is awaited. We have proceeded 3 steps towards, my lord, giving of the power supply. The power supply has not been given. They have stopped here in view of the litigation which is pending before the party.
Clearance delay, demand.
My lord, yes. After this clearance is given, they will make a demand to us, and about 3-4 crores of rupees I will have to pay for the purpose of obtaining connection. I am agreeable to pay that amount of money. Let them not give connection until your lordship passes the judgment. I am.
We shall endeavor to pass order at the earliest.
Lordship. This is the first point that I wanted to make here, with lordship, that the point that there is no application, that was never there. There was never the stand of DVC at any point of time. On the contrary, DVC.
No, that's also, I think, not the stand. What they say, it is not an application, proper application. An application should contain these documents along with that, etc., etc.
Very well, very well. Let us assume, for the sake of argument, this is not a proper application. I make a proper application in that format. Even then, in view of clause 6.10, will they be entitled to ask me for the arrear dues? This is what I am on. I make a fresh application. Tomorrow I make a fresh application. Until they can establish
nexus.
The nexus, they will not be entitled to charge anything. So, this period of time will be wasted. I make a fresh application. Again, the same exercise is undertaken. They undertake the exercise. I undertake the exercise. I go ahead with it. But will they be withhold connection in view of section 43 of the Electricity Act, read with my lord the regulations? Regulations now govern the relationship between the parties. If you say there is no application, I shall apply for no due certificate. You will say that this amount is due. I will say I will not pay that amount of money, give me connection. This is what it is, ultimately. Logically, it comes down to this. So, what does my learned friend's argument lead it to? In the meantime, what happens is this, DVC is deprived of this huge amount of money which they could have earned if I had been able to run my business. This is what, my lord, the Supreme Court has been crying itself forth. Take money, run your business. This is not the way you run your business. You stop the business. The business which will give you money, you are trying to stop that. This is exactly what is happening. My lord, I am respectfully submitting to your lordship. The argument my learned friend has made will lead to an absurdity in the sense that the Ninan's judgment on which my learned friend is relying, that will be, my lord, totally rendered nugatory, because they will not be able to, no business will be run from there. I am sitting ready with the money for the purpose of running a business. You allow me to run the business and take the money from me. And on this kind of technical ground, you were stopping me from doing so. When by no means you will be able to establish any connection, because there is no nexus between the two of us at all. I do not know Bishnath. But therefore, ultimately, the issue is clause 5.3.3, whether, my lord, that is complied with or not. Ultimate issue is 6.13. That, my lord, is this superseding everything else. Kindly, my lord, consider from that point. My lord, these are my responses. My lord, your lordship has been very patient. My lord had given a very patient hearing to both of us.
My lord, on a lighter vein, we both understood each other's argument.
My lord, only question is, to what extent, my lord, we have been able to convince your lordship? Both of us will be asking that question. My lord, very grateful to your lordship. Sure.
Serial number 10.
My office.
Lordship, I am filing affidavit of service, Lordship. To transfer.
Yes.
Lordship, actually, I preferred this appeal against the impugned order, wide order dated 15/5/2023. Lordship, at first, Lordship, I will give the proper focus on the crux of the writ petition. The crux of the writ petition is that the petitioner was an owner of the plastic company. After that, she let out her company, and the private respondent was the tenant. Private respondent committed some offense regarding electricity. After that, the electricity authority came to the spot and disconnected the line of the private respondent and as well as the petitioner. And one police case was also initiated against petitioner and private respondent. After that, Lordship, after investigation, then the petitioner was non-charge sheeted. And only against the private respondent, the charge sheet was filed. After that, Lordship, the petitioner filed the writ petition because the petitioner applied before the electricity authority because she was non-charge sheeted. So, all of prima facie from investigation, it is revealed that she did not make any crime. So, for the purpose of restoration of her electric connection, she made an application, and the concerned authority did not pay any heed to her application. Then she filed the writ petition. And then when the writ petition was heard, Lordship, in the impugned order, by order dated 15/5/2023, one other thing was pointed out that the writ petitioner did not challenge it under section 127 of Electricity Act. So all of what is section 1, I am asking myself for the purpose of enhancement of my knowledge, that also what is section 127 of Electricity Act. It is not if it is not properly assessed under 126, then the petitioner has an alternative remedy under section 127 of Electricity Act to prefer an appeal before the concerned authority. Now, Lordship, the question is that whether the alternative remedy, only the alternative remedy is the ground to.
That you may be right. In all cases, mere existence of alternate remedy will not be a bar.
And Lordship, I
But
have
what they
researched
say
the
is
judgments.
that particular assessment has not been made against the third party, against the writ petitioner also. That order has become final. And the earlier writ petition you had filed, and where the liberty was granted to clear the dues, you should have carried that order on appeal, intra-court appeal.
Under section 127 of
No, against the order in WPA 7626. In that, it was dismissed with liberty to pay. How do you escape the
liberty to pay, Lordship? In that event, Lordship, I did not make any kind of offense, Lordship.
This is not the forum, sir. If you had aggrieved by the order passed in the earlier writ petition, you should have filed a writ appeal against that intra-court appeal. In that, while dismissing the writ petition, court said you are at liberty to clear the outstanding. How much is outstanding?
Lordship, from my end, no outstanding is present, Lordship, from my end.
No.
29 lakh 72,098, and out of it 5 lakhs has been paid for the on the bail conditions. That 5 lakhs has been paid
at the time of taking the bail, Lordship.
In the assessment order, the learned judge has recorded that it is made you liable, the writ petitioner, as well as the private respondent.
jointly and severally liable.
You can't escape, sir. This intra-court appeal is.
But Lordship,
directed
in that
against
event,
order.
Lordship, kindly give me a leave to prefer an appeal under section 127 of Electricity
That is
Act.
already there, no?
That has already elapsed. So far, your Lordship knows the under 127
This
30
intra-court
days
appeal
that
is
has.
directed against order dated 15/5/22, by which the writ petition filed by the appellant was dismissed. The writ petitioner, the appellant writ petitioner, was sought for restoration of electricity connection to the premises owned by her. There was a tenant in the property who was a private respondent, and who was the private respondent in the writ petition. The learned single bench noted that earlier the appellant had approached this court and filed a WPA 7626 of 2023, which was dismissed by judgment dated April 10, 2023, giving liberty to the appellant to clear. Sorry, sir. The learned judge noted that the private respondent had filed a writ petition in WPA 7626 of 2023, which was dismissed, giving liberty to the tenant to clear up the entire outstanding. Further, it has been noted that the assessment has been made not only in the name of the tenant, but also in the name of the landlady, the appellant. The said assessment has never put to challenge in any manner, nor an appeal was preferred in terms of section 127 of the Electricity Act. Therefore, unless and until the entire outstanding is clear, the question of reconnecting or granting service connection to the appellant would not arise. For the above reasons, no ground has been made out.
I'm deeply obliged.
Sorry. Next.
Serial number 11.
My lords, I appear for the appellant. My lord, there's a connected appeal which was listed on 19th of June. My lord, this appeal was directed to be listed along with that appeal on the 26th. My lord, I'm praying both these appeals may be listed any day next week, subject to my lord's convenience, my lord. Mr. Shomo Majumdar had appeared and mentioned that there was another
This
appeal from the
along with so and so sometime next week.
Grateful, my lords.
Serial number 12.
I beg to appear for the appellant.
For the state management.
Yes.
This is my appeal arising out of the order dated 18th of May 2013. In a police election writ petition, the learned judge passed an order and gave permission to the writ petitioner to construct a boundary wall in in a land where I am the co-owners, but I have filed 3 connected applications, one leave to prefer an appeal, Section 5 application, as well as the stay application. But kindly have a look to the order. Kindly take up the leave to prefer an appeal. Can 3.
Yes.
Kindly have a look to the order. Last page. Page 42. Counsel for the state submits that the Saltoro police station already taken out proceedings under 107 of the CRPC and also registered FIR. There is a dispute with regard to demarcation of the petitioner's property. Such demarcation has been effected by the BLRO, and in the event of any objection as regards to demarcation, appropriate steps under the WBLR Act may be taken by the objector. The petitioner shall be entitled to construct its boundary wall.
But according to the finding, the BLLRO has already done the deep.
Kindly take up the writ petition. Without giving an opportunity to the co-owners of the land. Without giving any
ex parte order.
I am the co-owners.
Where is the BLLRO order?
Kindly take up the writ petition. I have not been included as a party in the said writ petition, despite having knowledge that I am the co-owners. Kindly have a look, page 50. This is the complaint.
He is not served. You have served notice on the writ petitioner.
My lord, I have some notice, but what I have been informed by the appellant that both the partners of the respondent number 1 writ petitioner has sold the property, including the license and the petrol pump. As I have been told yesterday, my lord, I must be candid to my lord. If my lord give me an opportunity to serve another notice, my lord, I will serve.
No, the petrol pump is the writ petitioner.
No, I have been informed that that is run by the another, some Mondol is running that petrol pump. I have been informed.
What is your
for state reports are there, my lordship. No police picket has been introduced at this moment because they have not paid any amount as such police cost. My lordship, point 3 and 4.
Till today, no boundary wall was constructed. That also.
No, till date they have not deposited that cost. So therefore, police picketing. But where is the order of the BLLRO?
My lord, page 5 of the writ petition, there is.
We don't have the writ petition.
Page 5 of the writ petition, no copy of the writ petition has been served upon me. I have downloaded it from the Sarthok as soon. But kindly have a look.
We don't have a copy. You pass on that copy.
Paragraph 12. That is a statement. No document has been annexed.
Whether the BLLRO is a party,
No,
but what happened to the notice sent by you? It is returned.
no, that has been kindly have it.
Show the affidavit of service. Deeptesh, please verify. But how police can get into all this dispute? He says he is a co-owner of the property, and the other two co-owners have sold the property to
I'll
a.
kindly have a look to the documents I have annexed in my CAN 3. Co-owner, number of co-owner, at least 25 co-owners are there. Not a single person, not a single owner has been made a party implicated in the writ petition.
23. We have heard the learned advocate for the appellant and Mr. Somnath Ganguly, learned state advocate, assisted by Ms. Priyamvada Singh, learned advocate for the official respondents. The private respondents writ petitioners have been served and affidavit of service has been filed, but none appears for the writ petitioner. The appellant herein is a third party to the proceedings and has sought leave to file appeal. The learned single bench by the impugned order has directed police picket to be provided at the cost of the writ petitioner and also made an observation that the writ petitioner is entitled to construct a boundary wall. The learned advocate for the appellant would strenuously contend that no proper demarcation has been done by the revenue authorities and that there are several owners to the property and none of them were put on notice, more particularly the appellant. In the light of the above, the appellant is definitely an aggrieved person and therefore leave to file is granted. CAN 3 of 2024 is allowed. Since leave to file has been granted, and the court is satisfied that the appellant was required to be heard in the matter, CAN 2 of 2023 is allowed and the delay in filing the appeal is condoned. The writ petition was filed by the private respondents herein, praying for
Unbefilling state.
Direction upon the officer in charge, Salthora Police Station, District Bankura, to take action on the complaint dated July 30, 2023 and conduct a fair investigation and remove all obstructions caused at the land comprised in plot numbers 254 and 258 with Kaitan number 555 of Mausa Kashipur, JL number 12, Police Station Saltora, District Bankura. The writ petitioners also prayed for deployment of adequate number of police personnel in the said property. The writ petitioners claim that they have converted the land in question for the purpose of running a petrol pump, and the same has been approved by the subdivisional land and land reforms officer, Bankura Sardar, on 18/7/2019. The dispute brought before the court by the private respondent is that some persons are obstructing the construction of boundary wall at the backside of the land. Further, it is stated in the writ petition that pursuant to a meeting on 29/7/2022, the block development officer, Saltora block, and the officer in charge of the police station demarcated the back portion of the land by spotting bamboo stick. Admittedly, the matter concerns right to an immovable property, and the appellant claims to be a co-owner of the property. In any event, the dispute being civil in nature, it is but appropriate that the police do not interfere in the matter unless there is a breach of law and order or any criminal offense is committed. Therefore, the demarcation has to be done by the proper authority of the district administration. Therefore, the appeal is allowed and the order passed and the writ petition is set aside, and there will be a direction to the district magistrate Bankura to direct the concerned block and land reforms officer to inspect the property after notice to all concerned. That is the writ petitioner, the appellant, and all other co-owners of the property. And upon such inspection, the boundary, if can be ascertained, should be fixed, and thereafter the parties should be left to work out their rights in the manner known to them. Further, we note from the instruction given by the written instruction given by the police, the writ petitioner has not remitted the cost directed to have been remitted, and therefore no police picket has been granted. However, strict vigil has been maintained in the area with the above direction. Appeal disposed. Let the district magistrate please, because the dispute in order issue notice to the petitioner, writ petitioner, private writ petitioners, appellant, other co-owners, and also the neighboring landowners. Yes. You stop. 3:30.
But before your lordships rise, but this one matter, item number 85 of your lordship's list. But may it be taken up on Wednesday at the top lord, because your lordship once granted me that relief. It was coming as 19, but then it could not be taken up. Item number 85. It's an election dispute of the Chartered Institute. I'll give notice, but if your lordship kindly.
Can you just give me this week? You please excuse me. Then let it run in the list, because there is back-to-back programs on this Friday, Saturdays.
I'm grateful.